brackets on. My name is Fasia Hassan. I'm also a member of the Portfolio Committee. I've also just got a few points and questions. Let me start by appreciating the different stakeholders and members who've taken the time to make presentations today and to submit. Of course, we still will welcome everything in writing so we can go through it. I have just a few points. To the first gentleman, I think Mr. Sydney, I can be getting the names wrong, so please do forgive me there. I'm just interested in your thoughts there after what you've presented about whether you think it may be correct or helpful to cap the price of gas to ensure that even the poor has access to gas, particularly for heating and for cooking. I also wanted to speak to this most recent presentation, the third one around green hydrogen as well. I'm interested in the thoughts of the presenter on the impact of the expense, rather, of green hydrogen inclusion. So if we include green hydrogen in the mix, what's that going to do to the gas price overall? Won't it increase the gas price and won't that affect affordability? That's very important for us to ensure universal access, particularly for the most vulnerable, the poor and the working class. I'm not asking a question on the green element. I think that's clear. I think there's a case for that. I'm asking around the affordability and the price. And then the second gentleman, I'm in full agreement. I think that the smaller players in the market are always the ones who are knocked out and I think the most squeezed. The big guys hog onto those cylinders at the plant and squeeze the small guys out. So I also want to note that as an anti-competitive behavior from the big guys. I think that's something that we as the Portfolio Committee need to look into, Chair, and also to support many of those who are smaller players in the market, because if we don't, we're going to have a major problem also going forward. I'm also interested to know, that deposit that we as members of the public pay for those cylinders. It would be very interesting to know where exactly that deposit goes to, because I think that's also part of sometimes the challenge on affordability. But with that, Chair, thank you very much.
Thank you, Honorable Hassan. We will now take the responses. Let's start with Mr. Maswane. I'm hoping that each presenter had captured the questions that are directed to their particular presentation so that they can respond on that. Yes, Mr. Maswane.
Thank you, Chair. I didn't capture well the questions from Honorable, is it Hassan? She was a bit fast, so I was trying to catch up with her on the two questions she posed to me. I think it were around the pricing. So if maybe, Chair, you would allow her to just repeat those two questions so I can capture.
Honorable Hassan.
No, thanks, Chair. Sorry, I'm also in a meeting at on the other side as well. I just wanted to ask their views and whether it's correct to cap the price of gas to ensure that even the poor has access to gas for heating and for cooking. So it's around the affordability and it's around capping the price. Thank you.
Mr. Maswane. Okay, I think I will come back to Mr. Maswane towards the end. Let's take Mr. PK.
Thank you, Chairperson. I don't think it was a question per se from the honorable member, but I appreciate the members that they appreciate my submission. And in reality, this thing of what happens to the bottles, you have your own branded bottle. You cannot refill the other people's bottles, so you can only fill yours. So when the customer bring in another total gas or a frogs, you can't refill that, and then you give them your own. That customer, you can't stop them from taking your bottle to other retailers, and then they keep your bottle, they give her theirs, and then when she comes back to you, she comes back with a different bottles, and then that retailer doesn't cooperate in giving you back your bottles. That is a very bad game. What happens to the Honorable first ask? What happens to the deposits? The deposit we keep and we try to amortize the cost of the bottles. The cost of the bottle itself is almost 3,000% times what we ask for the deposit. And then we try to amortize it. So those deposits, we put it aside. They are nothing compared to the cost of the bottles. They are the fresh in 3,000 to 6,000 compared to the 300 deposits that you give the customer if they don't have a bottle. We try to amortize the cost of the bottle, but the deposit, we keep it aside until then so that you can buy your new bottles at the end. I don't know if there are other questions here. I didn't hear the other question from the other honorable member.
Thank you so much, Mr. Peter. We'll now move on to quick responses from Mr. Takolia.
Hey, thank you. So I'll try to answer the series of questions. Yeah, so if just to give context, so I always like to use solar as a good benchmark, and why the first slide that was presented earlier presented solar. So today, if you look at RDP houses, they put a solar panel on with a geyser. And that has become feasible in the last 3 to 5 years. But 10 or 15 years ago, it was totally unfeasible. So with hydrogen, as I mentioned, we are on the path looking at technology, and there's so many developments happening globally. We have hundreds of universities looking at how to make hydrogen competitive, including South Africa's research institutions and universities. So we are not competitive today, and the idea of the submission for the bill is to ensure that, if the bill is not updated, let's say for another 10, 15, 20 years, or the Act or the Gas Act is not updated, that we already cater for low carbon gases or green hydrogen into the system. I have visited China, for example, where you can take 1 kilogram of hydrogen and put it into a motorbike, and it runs for the entire day. And they are trialing out systems, for mobility, for low-income people, and also hydrogen buses and trains and those type of things. So there will be applications. It will take time. And the main idea is to create the space in the bill that when these things become much more feasible, that it won't require too much work, or there's nothing that would prevent this type of economic activity from being undertaken. So that's the main basis. In terms of context, the gas cliff, which is also a slide that was presented and which is widely reported, is showing that there will be a decrease in gas supply. And that mainly goes to industrial customers. So it could be that if we replace the synthetic gas or the natural gas with hydrogen, yes, it may be slightly more expensive, but the carbon emissions from that is lower. So it improves their carbon emissions, and if they export, it improves their export competitiveness. So there are lots of trade-offs that will need to be considered as we go down towards competitiveness with the fossil fuel alternatives. But it will take time, and I do think it will initially happen on a case by case basis. I think for community development, there are lots of studies, and it's also included in the commercialization strategy, which was ratified by Parliament. South Africa has significant platinum group metals. The electrolyzer, which is one of the units using proton exchange membrane technology, using platinum group metals is one of the preferred choices for you making hydrogen from renewable energy. So there's lots of spin-offs, or let's say the platinum industry. Also, if we can produce the hydrogen locally, we can have local community development, because sun and wind occurs in the urban centers, but also some of the best sun and wind are in rural areas. So if you have access to sun and wind and some water, you can make a fuel on site or closer to communities, and there can be significant community development. And like the example I gave of the RDP houses that now have solar geysers and solar panels, that could be an opportunity in the not too distant future for economic development and also creating local supplies of low carbon and renewable gases. So I think I try to answer everyone's questions, but if there are any more, I'm happy to take them.
Thank you so much, Mr. Safalia. I do also appreciate the presentations that we had received from Mr. Masuane and Mr. PK. Thank you so much for such a well put together presentation towards these public hearings. Thank you so much. We'll now move on to the other three presentations, and then afterwards we'll give space for the clarification questions and responses thereof, and then we'll obviously go to lunch. So first up, we are going to be taking vets from school. Indicated here is that Professor Crompton is doing the presentation. Mr. Kotze is Professor Crompton or any other representative already on the platform. So
I spoke to the Prof earlier, Chair. He is on the platform.
Okay, please do make him co-host so that he can be able to do the presentation.
Prof, can I just see where you are? Oh, you were the AI, so I should give that one the co-hosting.
Thank you.
There we go, Prof.
Good morning, Chairperson and members of the committee. Thank you very much for the opportunity. I'm sharing my screen now. Hopefully you should be able to see it.
Yes, Prof.
Yes.
Okay, thank you. Thank you very much. So I'm here in my personal capacity. I'm not representing Wits University in this matter, although I do work for them. I also work for Crompton Consulting. So just a little bit on why this person in front of you is talking to you. When I was DDG at the Department of Minerals and Energy, I was the chief government negotiator for the Romco pipeline deals and the two contracts that resulted from that. And one, as you know, is appended to the current Gas Act. I was also responsible for drafting the Gas Act in 2001. I spent 11 years as a full-time regulator at NERSA. I've also served on the boards of those companies you see there, state-owned companies, several of them. And whilst I've been in academia these last several years, I've done quite a bit of research and consulting work around gas. So I do support the need to review the Gas Act. And we should all bear in mind that it's taken 25 years to get to this point. And it may take another 25 years before it's reviewed again. And that is something that we need to take into account in doing new legislation, because it's likely to be around for a long time. So the context that we are operating in is one of rapid technological change, particularly in the energy sector. We have no gas policy for the country, and we are what I call back to the future. If we compare the market situation 2001 and 2026, we are essentially, from an LNG point of view, in exactly the same situation. There was no natural gas in 2001. It came in after that in 2004. The same is true for LNG today. There's no LNG happening on an industrial scale, and it's likely to come in the next few years. When we drafted the gas bill back then, we did a lot of consultation locally and internationally. And the conclusion of all that was that we should treat gas as an infant industry. And in my longer submission, I've spelled out more reasons for this. But my appeal to you is to treat the LNG industry and the other new industries that are emerging as infant industries in this legislation. Therefore, we need light-handed regulation for infant industries. This was the essence of the international and local advice we received at the time. So what does light-handed regulation mean for the LNG industry? So it means favoring commercial outcomes rather than heavy-handed regulation. It also means that we should regulate tariffs for the natural monopolies, the infrastructure, that is to say, for pipelines, for storage, for regasification facilities, and the like. The real issue for investors in the industry is the maximum gas price regulation. That is now the molecule, the price of the gas molecule I'm talking about, not the cost of using the pipelines or the storage or loading facilities or that kind of infrastructure. So my view is that what we need regarding maximum gas prices is a guideline, not a regulation. So a guideline would mean something that NERSA develops and is out there for industry in much the same way that the Department of Mineral Resources and Energy does a guideline for diesel pricing, but it has never and does not regulate the diesel price. Only a slight difference. What I'm suggesting is that we should differentiate the guidelines by source of gas. We're going to have in the near future competing sources of gas. We might have more gas from Mozambique coming down the Rompo pipeline. It looks like we'll have LNG. It looks like we'll have onshore small volume gas. It looks like we might have methane-rich gas. It looks like we might have offshore natural gas. All of those things have very different cost structures, and it's not reasonable to have one price that deals with all of them. So much as we have with electricity, if you buy electricity from a particular producer, you pay the price to that producer. You also pay the national transmission company for the use of their assets to transport your electricity from the producer to the customer. But the actual electron price is what's agreed between the buyer and the seller, and the same, I'm arguing, should happen for gas, according to the source of the gas, which gas you are buying. There should be some protection for vulnerable customers, and so I'm suggesting that the guideline price could be converted to a regulated maximum price for customers that request it. This would be on a customer-by-customer basis, and since NERSA will have done the consultation with the public in developing the guideline, there would be no additional red tape or additional public hearings and consultation. That customer would simply get a regulated instead of a guideline price if they are deemed to be a vulnerable customer. Why do I suggest this? Well, I'm speaking mainly about LNG now. LNG has very long capital-intensive value chains from the gas well to the customer. And if you think about it, there's someone in another country is investing lots of money to drill wells and to produce natural gas. To clean it up costs money, to put it on a ship costs money, for the ship to sail to South Africa, to discharge it, to put it through a regasification facility, and then start selling into the market. That's a very long value chain. And to get it to happen, investors will all require long-term offtake agreements. So there will be back-to-back long-term agreements over volumes and pricing. For LNG at the beginning, where we are now, the baseload customer is going to have to be power generation because Sasol has said it cannot afford LNG. So power that's produced from gas, that electricity is already regulated by NERSA. So there's no need to regulate the gas price going into gas to power stations. We also know from the RP 2025 that the government has already fixed the capacity factor for gas to power stations. So that uncertainty has already been removed. What about the South African wholesale electricity market, which is due to start later this year? Will that affect what I'm suggesting? Well, it will when the gas market grows past the infant industry stage. And it's very difficult to predict how long that will take. I mean, look how long it's taken us from Mozambique gas. It's taken 25 years before we've really hit the gas cliff. So who knows how long it will take. If you look at the RP, there's quite a lot of gas to power capacity built in there. It's not clear if it's going to happen, but it might happen. Anyhow, at some point, we will have a gas market and we will move to a wholesale gas market in much the same way as we are doing with electricity. In the meantime, LNG is going to be governed, as I've suggested, by long-term offtake and price agreements. Now I want to talk about secondary markets. This is the trading or reselling of already allocated capacity in infrastructure. So I'm talking now about pipelines, storage, regasification facilities, and so on. They are only going to be built and are usually built when much of the capacity in those things is pre-booked, if I can put it like that, with a use or pay agreement or an offtake agreement. Not always, but that's often the case. So with long-term use or pay agreements or contracts, the global market is changing. We've seen rapid changes as recently with geopolitical factors coming in, for example. So people who have rented capacity for a long period may want to change, and there may be others who value it more. So by allowing a secondary market in this capacity, it gets to the shipper who values it most. The tariff is not affected. The tariff for a pipeline, for example, will already have been set by NERSA. So there's no need to regulate it, and there's no need for regulation to be involved in this purchase and sell of capacity. All that needs to be in the bill is the right for people who've rented capacity to buy and sell it. At the moment, we don't regulate customers of pipelines, so there's no need to regulate this either. For those who have competition concerns, I've looked into this, and in short, the Competition Act applies, and it's quite capable of dealing with any market malfeasance that might arise from this secondary trade. Some other issues. Third-party access is a big deal when it comes to establishing competition in markets. There's a need for the Act to define it. Don't leave it to a politician, as is currently suggested in the bill. This is far too important a term to be dependable by investors. They need to know exactly what it means when you say third-party access, because it has many different meanings to different people, believe it or not. So if a definition is included, as I suggest, and I put in my presentation an example, then you also need to delete section 31(1)(h) in the bill. The next issue is political and ministerial discretion. There's a lot of it in this gas bill. It's bad for investment, and my appeal is that you reduce it as much as possible. There's also a section 2I in the bill promoting equitable provision sound, which in my view, the wording is meaningless. So I suggest you delete it. There's also a provision in the bill for a thing called an integrated energy project, which is not defined, except in a sort of circular fashion. We had similar wording in the Electricity Regulation Amendment Act, which I understand this committee removed from that act, and I'm suggesting that it also be removed from this bill, because it's a source of potential confusion and overlapping jurisdictions between different acts, electricity and gas and so on, and a source of uncertainty for investors. So I'm suggesting that be removed. My last appeal is borrowing the words of Rudy Dix, the head of project management in the presidency, and Duncan Peterson, the Director General of the Treasury, is when we are finalizing this bill, bear in mind the people who have to implement it. And in a way, Parliament is part of this implementation. And they say, Albert Hirschman, the economist, spent his career studying why structural reform is harder than expected, but more achievable than assumed. He wrote about reform mongers, people engaged in the unglamorous, difficult, and politically contested work of navigating resistance, building coalitions, and making partial progress under imperfect conditions. It sounds a bit like exactly what parliamentarians do. Improvisation mattered as much as design, and outcomes often surprised advocates and critics. South Africa does not suffer from a shortage of ideas on how to transform the economy and create the conditions for faster growth. The challenge has been to translate those ideas into action. And that's my appeal. Allow room in the Act for people to implement progress, because we sorely need economic development. Thank you very much for the opportunity.
Thank you, Mr. Crompton, for your presentation. We do hope that you stay on. We will receive 2 more presentations and then we'll get clarification questions. We will now move on to the Center for Environmental Rights. We did not hear who from this particular stakeholder will be presenting.
Hi, good morning, Honorable Chairperson, honorable members of the committee. My name is Paul Lado, and I'm an attorney at the Center for Environmental Rights. I will be talking us through our submission on the gas bill, focusing on a few key areas that we think are important. But we highly recommend that our full comments are perused and considered on this gas bill. From the outset, I would like to emphasize that the submission by the CER on the gas bill is not inherently opposing the development of a legal framework to govern the gas sector. We believe that there should be a strong law governing petroleum development should the government go ahead with that. Our concern is that the bill itself does not provide sufficient robust governance safeguards to ensure that gas development occurs in a manner that is transparent, constitutionally compliant, and environmentally responsible. So our comments focus on strengthening the governance architecture of the bill. And our first point speaks to public participation. Many of us will be aware that meaningful public participation is a constitutional requirement. It is also essential to building public confidence in decisions relating to major energy infrastructure. While we do note that the gas bill contains opportunities for participation, we are concerned that it does not consistently require participation at all key decision-making stages, nor does it adequately promote transparency throughout the licensing process. Communities, both local and directly affected, cannot meaningfully participate if they lack access to the information necessary to understand how decisions are made or how projects may affect them. We therefore recommend in our comments the strengthening of the public participation provisions within the bill and the ensurance of greater transparency throughout the licensing process. Honorable members, tied very closely to that first issue is our concerns around the licensing framework. We note that the bill confers extensive powers on the Minister and the Petroleum Agency of South Africa, but in many instances within the bill, it provides limited statutory guidance regarding how those powers may be exercised. We feel that a modern regulatory framework should provide clear decision-making criteria. This would inherently promote consistency, accountability, and legal certainty. Our recommendations, therefore, seek to strengthen the statutory criteria governing licensing decisions rather than expanding administrative discretion. Honorable Committee, our third concern speaks to the relationship between the bill and South Africa's broader environmental and climate governance framework. South Africa has adopted important legislation, including the National Environmental Management Act and, very recently, the Climate Change Act. We make submissions that the gas bill should complement these frameworks and avoid creating parallel or fragmented systems of environmental governance. We thus recommend a clearer alignment between the bill and existing environmental legislation, specifically where decisions made therein would have significant environmental or climate implications. I now move to our comments around both the gas master plan and strategic integrated energy projects, both referred to in the gas bill. Now, we do believe that strategic planning has an important role to play. However, national planning instruments should guide future development without diminishing the need for project-specific environmental assessment, meaningful public participation, or independent decision-making. We thus feel that where the gas bill provides for the designation of a project as a strategic integrated energy project, there should not be a reduction of the level of environmental scrutiny applied to such designated projects. I now move to the question of exemptions. Our submissions on this point are very clear. Exemptions should remain exceptional. The bill should clearly specify the circumstances in which exemptions may be granted. It should require written reasons for those decisions where exemptions are granted, and it should ensure that exemptions cannot undermine the environmental and governance safeguards that Parliament seeks to establish through the legislation itself. Finally, we move to Clause 33, dealing with the expropriation of land. We do understand that it is an extraordinary power to expropriate land, and we highly recommend that the bill expressly state that expropriation may only be exercised as a measure of last resort where no reasonable alternatives exist following meaningful engagement with affected rights holders, and where the minister is satisfied that the proposed gas facility serves a compelling public purpose or public interest. Essentially, Chairperson and committee and others on the call, our submission is ultimately about good governance. We support a strong regulatory framework that benefits everybody, improves public confidence, reduces the likelihood of litigation and disputes, and better equips South Africa to achieve its constitutional and environmental objectives. We therefore respectfully request that the committee consider amendments to strengthen the bill's provisions as provided for in our comments submitted last week, Thursday, the 6th of August, 2026. We thank the committee for the opportunity, and we are open to any questions. Thank you.
Thank you so much, Mr. Ladley. Please stay on. The questions will be asked immediately after this last presentation for the statement by Vilgro Energy.
Good morning, Chairperson and members of the committee. I hope you can hear us.
Yes, sir.
Thank you so much. My name is Pinda Vilagazi, presenting today on behalf of Vilgro Energy, supported by our leadership team. Vilgro Energy is a company involved in gas consulting, project development, as well as trading. The company is still relatively new, but the founders are quite experienced, having worked in this industry for more than 60 years across many different locations. Myself, as the CEO, I have worked on gas projects here in South Africa, as well as in the Middle East, Qatar, Nigeria, and the US. but specifically also closer to home, looking after gas distribution infrastructure, both in South Africa and Mozambique. I would like to then also introduce our members. We've asked Mr. John Sichinga to lead our contribution. But first and foremost, we would like to say we appreciate the opportunity to present today and also commend the work that is being done to relook at the gas bill. We believe, given our experience, we can also contribute to ensure that we have regulation and legislation that are going to enable this industry. If Chair, I can then have the opportunity to ask Mr. Sichinga to introduce himself briefly and then take us through our contribution. Thank you.
Thank you very much, Mr. Vilakazi. Thank you for the opportunity to present our submission. My very brief background, I spent most of my corporate career at SASO. Prior to that, I worked for Anglo. At SASO, I left when I was Senior Vice President over the Oil and Gas Division. So ultimately, I was responsible for the operations in Mozambique. We also had some facilities non-operated in Gabon for oil, crude oil, and in Canada for shale gas. As Mr. Vilakazi has said, we've had a lot of experience globally on gas monetization projects, mainly gas to liquids. I was personally involved in Qatar, Iran, to some extent in Nigeria and Uzbekistan. So if I can then move on to the next slide, hopefully everybody can see it. So there's been a lot of discussion in the public domain around the gas cliff. Firstly, we would like to note that and gas, as everyone is aware, is a finite resource. So ultimately, it was supposed to come off the plateau. Operations in Mozambique, Pandetemani, started in 2004. And the expectation was we would stay on plateau until around 2030. But due to some complex geology, we anticipated coming off cliff around at least four years sooner. What has happened since then, as most members likely to be aware, is that SASO has extended the plateau further up to about 2028. And then between 2028 to 2030, its methane-rich gas is supposed to be supplied from Secunda. And then LNG imports are supposed to come into play post-2030. So ultimately, if this plays out, there shouldn't be a gap in volumes. The challenge is in pricing and volatility in that regard. If I then go on to the next slide, the paradigm shift has been discussed previously. We had a single source for industrial gas from Pandetemani through the Romco pipeline into the SASO gas distribution network. And then there was a line from Lily pipeline, Secunda, going to Richards Bay, Durban, which was methane-rich gas, MRG, from Mozambique. The transition then goes into future market where there were potentially multiple global suppliers. Spot global LNG pricing could be a factor, although typically you would have 70 to 80% term oil indexed, 20-30% could be spot on indexes such as JKM and TTF. And then there's likely to be gas and gas competition, and then open to domestic exploration in the Orange Basin, say from Namibia, where there's associated gas that might come into play through pipelines in the future, potentially. Firstly, would like to state that there's significant progress made in the bill, has already been discussed around third-party access, the recognition of LNG, functional unbundling, market transparency and enforcement. And so the framework modernizes the previous law, the Gas Act, the Gas Law of 2001. However, having said that, the core misalignment is regulating for, in our view, the past versus enabling the future. Supply was historically a single supplier, and that's appears to be what the legislation is intending to regulate for, rather than post 2026, where, as I've indicated, multiple global suppliers, multi-node and virtual pipelines, volatile global pricing benchmarks, and flexibility and dynamism. It might be unintentional, but that's what it appears to us. The other aspect, the first risk we want to highlight under section 18 is the gatekeeper effect, where you have multiple willing LNG suppliers and traders. The LNG terminals that are being proposed, some of them, like the Richards Bay, is open access, although the effect might be a closed access because of the dominant capacity that's been booked by one of the, or two of the traders. However, there's still some option for open access, and the bill makes provision for that. So you've got licensed distribution companies, and on the other hand, you have willing industrial buyers ready for commercial risk. Under Section 18, all customers except those explicitly determined eligible by the minister must purchase their gas through a regional distributor. The consequences for this is that distributors enjoy geographic exclusivity and act as gatekeepers. Direct buyer-seller interactions are blocked, destroying the liquidity and price discovery essential for gas and gas competition. The second risk is the static price caps in volatile global markets. As I've indicated, if term pricing for LNG tends to be crude oil indexed to a slope of between 11 to 15%, and term pricing could be one of the global markers like JKM and TTF. And there's volatility which could be influenced by weather events, shipping costs, as we've seen currently influenced by geopolitics. And therefore you could have $18 per million BTU or $8 per million BTU. A million BTU and gigajoule is almost equivalent. The bill defines excessive pricing as higher than a competitive price, but in global spot pricing, $8 and $18 can both be perfectly competitive prices in consecutive months. So the regulatory overlap in this regard, in our view, is that risks creating dual regulation between NERSA and the Competition Commission, leading to potential for forum shopping. So you go and shop whichever regulation suits you best. The third risk that we identified is the exclusion of virtual pipeline in the form of SS LNG, small scale LNG. Could have been intended, but maybe as an oversight. CNG is indicated, compressed natural gas. And the difference is that CNG is relatively cheaper as a process, but more expensive from a transportation perspective because of the lower energy efficiency. So typically, small-scale LNG will become more effective around distances of 400 to 800 kilometers. And this has an effective developmental role to play in emerging markets, as I'm going to indicate just now. Close to us, we've seen CNG play a role in Mozambique, where it's initially started as virtual pipeline through Matola Gas Company before enough demand accrued, and they were able to establish permanent pipelines. In South Africa as well, we've had quite a history with CNG, but small-scale LNG is fairly new. Risk 4 is debottlenecking investments versus decrease. Again, this has been indicated already. The bill requires broad ministerial determinations for large new transmission and regasification projects, centralizing control over private capital, which as a consequence is justified for state-backed assets, but applying decrees to private project introduces severe political risk and timing uncertainty. Global LNG succeeds where governments set policy, regulators regulate, and private sectors build. The other aspect I wish to highlight here is that liberalization sequences are breaking the ceiling. We've indicated it's positive third-party access to infrastructure. However, the step 2 is a regressive reduction of eligible customer threshold. This is under Section 18, which traps and restricts through mandated gatekeepers. However, step 3 is open and competitive gas markets, which is where we wanted to get to. This potentially would result in reasonable pricing for the off-takers. I've got a couple of international examples that I'll quickly run through. I've looked at third world countries which have introduced LNG and how that was done successfully. Countries like Brazil deliberately opened the market to reduce the influence of its national company, Petrobras, which has the direct parallel to South Africa, moving away from historic dominance by one entity. That has been very successful in Brazil with over, I think, 9 FSRUs that have been introduced, floating storage regas units, which are import terminals. India targeted more transition from domestic gas to LNG, similar to what we're going through. In our case, it's not necessarily domestic gas, it's regional gas through aggressive third-party access and declining incumbent dominance. It supported the fertilizer industry and manufacturing sector. China, I think what I want to highlight here, as well as Indonesia, is the role that small-scale LNG and so-called virtual pipelines played. In China, they developed satellite stations and tracked LNG to stimulate industrial demand before extensive physical pipelines were built. And similarly in Indonesia, mainly in Indonesia, they use it for industrial use and power generation. Getting close to a summary of the key aspects that we are proposing that are considered actionable policy pivots to enable investments. The first one is the discretionary ministerial control. As I indicated, we need to democratize access, replace discretionary ministerial control over eligible customers with objective criteria and phased reduction pathways. The second aspect is the mandatory distributor obligations, the so-called gatekeeper's role under Section 18, which we propose to be amended to remove mandatory distributor purchasing obligation, allowing direct buyer-seller contracting and market liquidity. Thirdly, we indicate that we propose recognition of market pricing, given the volatile nature of global LNG pricing, and given that South Africa will be a price taker, which we exempt global traded spot LNG from rigid excessive pricing and domestic caps to leave market conduct oversight to the Competition Commission. Lastly, the role of virtual pipelines, CNG, or compressed natural gas, has been indicated. We request that SS or small-scale LNG be explicitly included as well. Lastly, their national economic growth covers several areas in a dynamic gas market. We need to attract private capital for rapid deployment of import terminals and virtual pipelines. As I've indicated, there's a potential gap between methane-rich gas, MRG from Secunda, and the importation of LNG, which is supposed to come in 2030. There could be a gap if we don't have the right policy frameworks in place. We need to protect and create jobs, preserving the existing industrial employment created by imported pipeline gas from Mozambique. And we need to avoid the impact of the so-called gas cliff. Gas, LNG, natural gas is cleaner for industrialization versus alternatives like diesel and heavy fuel oil. It, in fact, even imported LNG potentially could be cheaper on an energy basis than diesel. Then there's an aspect of potential regional integration where each nation in the SADC region plays its potential to its potential strengths. Countries like Namibia, Mozambique potentially have access to large volumes of competitively priced gas, while South Africa has an extensively undeveloped industrial base that could be a sink to enable the development of gas industries domestically in those two countries I've indicated. Lastly, we need to incentivize exploration. We believe at Vilgro that there's still adequate run room in southern Mozambique with the marginal and stranded gas discoveries in that basin. This exploration could be incentivized with the right pricing structures in an anchor market like South Africa, which could contribute towards addressing the gas cliff. Thank you very much on behalf of Vilgro Energy for this opportunity. I'm happy to take questions if required. Thank you very much.
Thank you so much for the presentation. We are now going to go on to take the clarification questions. And please do remember to indicate to honorable members that there is a question we need to do so that they can be mentioned to respond afterwards. Are there any clarification questions? Okay, so we have seen the program that we had planned that we go to lunch. Okay, Honorable Mbotsa, I'll come to you now. We'll go to lunch at 1:15. So we are going to continue taking the other presentations so that we go to the lunch at 1. We had already taken the presentations from we'll start with natural justice and then it will be LP, USA, and then SASA will go after the to come on itself, and we'll take double ticketing questions and then go to lunch. So that we go to lunch with one as planned. Almost in Gosi.
Thank you very much, Honorable Chair. Greetings to you and all honorable members and all the presenters today. Honorable Chair, just hope I'm not going to be technical in terms of my questions. I only have two maybe questions that maybe I needed clarity on. Those are questions based on Dr. Rod Crompton's presentation, Honorable Chair. The first one will be on, I think it's slide 4 and 6, alignment of the broader energy legislation. The presentation suggests the deleting integrated energy project alignment to match the Electricity Regulation Amendment Act. Chair, I just maybe wanted to get clarity. How will the gas to power project be coordinated between the Gas Act and Electricity Regulation Amendment Act if this definition is deleted? I just wanted maybe to get clarity on that one, Chair. Secondly, Chair, it's on, I think it's also on slide 6, deletion of section 31, 1H and section 2I. I want to get maybe what are the legal and practical implications of removing section 31I, 1H and section 2I. Chair, that states open clause promote equitable provision, close quotes. Does removing equitable provision risk undermining the triple BEE transformation or small scale operator inclusion in the gas sector? Chair, those are the clarity seeking questions maybe I just needed answers on. Thank you.
Thank you. Honorable Drink, I see you have unmuted yourself. Do you have a question to ask or you just unmuted?
My apologies, Chair. No, there's no question from myself. Thank you.
Okay, thank you. Can we please get the response? I believe both questions be directed to the committee.
Thank you, Chairperson, and thank you, Honourable Nkosi, for those questions. Firstly, regarding integrated energy projects, I mean, the short and succinct sort of answer might be to put it, and I hope I'm not being cheeky here, but you know, why did this committee delete that provision from the Electricity Regulation Act? Because the same thing will apply. It was a very similar term, also not well defined, but also envisaged cooperation between gas. So that's a sort of tongue-in-cheek, and I apologize if I sound a bit cheeky. I don't mean to be. But in practice, to deal with you know these projects, as I tried to indicate in my presentation, for an LNG project to succeed, at least the first few in South Africa, gas to power will have to be part of the baseload, and there will be long-term take-or-pay agreements and price agreements will have to be part of it. Otherwise, it's just not going to happen. It's not going to happen. No one's going to build a gas to power station in the hope that they might get a gas supply. So there is no real need for government to try to project manage these things. I mean, the private sector is keen to get into the South African market in the LNG industry. I know this from my experience in dealing with some of the interested parties, and it's regulation which stands in the way. So we need to remove the uncertainty that this term integrated energy project introduces, because it's, you know, if I want to be rude, it's essentially whatever the minister dreams up is going to be an integrated energy project. And with the greatest of respect, ministers are not technically trained experts in gas and LNG or electricity for that matter. That's not their requirement. That's not why we elected them. So it's best left to the market to sort out these things. And it's not going to happen unless the pricing all the way along the value chain works. And as I pointed out, the electricity price is already regulated. So that's, if you like, that's the backstop. Everything that happens up until the final electricity price has to take that into account. So the exchanges down the value chain all have to take that into account, because that's the ultimate barrier, as it were. So yeah, it's essentially to move to a more light-handed regulation, to remove political discretion, which is not good for investor sentiment, and to let the market do it. Coming to your second question, you know, 2I, essentially, there's a phrase that used to be used when I used to present laws to Parliament years ago. The State Law Advisor would tell us, it's void for vagueness. And I think this kind of provision qualifies there. You know, I mean, what is equitable provision? You know, it's like, what is reasonable pricing? I mean, there's no real answer to these kind of things. So it doesn't really have any impact. It just becomes words. And so that's why I'm suggesting don't clutter the bill with just words that have no direct impact. Thank you, Chair.
Thank you for those responses. Thank you to all our presenters for this segment, as well as the clarity that you've received. And we are going to be in another second for the April deliberations. So making the assurance on the part. So now we, as I indicated before, that we are early. So we are going to then add on the other three presentations so that after lunch, we know that we are dealing with just one segment and would then be able to go and join the plenary, which we were granted that we can participate in the committee work. But I do think that if we can use this time, even if we're an hour late, but we can be able to join the remaining proceedings of plenary. So I request the indulgence for all of the members, and we do proceed to take presentations from Natural Justice, LPG, SA, and then SASO, as well as therapy seeking questions and responses before going to lunch. Lunch will still be at 1:15 as planned. So we will then take the presentation from Natural Justice. Mr. Kodze, please put them on as co-host if they are already in the platform.
Natural Justice is on the platform, Chair.
The platform is there. Present.
Natural Justice.
Good morning, Chair, and good morning, committee. I just would like to clarify if I am audible.
Yes, you are.
You're audible.
Thank you very much. Mr. Katsia, I'm wondering if you'd be able to share our presentation or just go through it, or if you'd like me to just...
Yeah, I've given you co-hosting rights, so you can project.
Okay, just give me a moment. Just confirm if you can see the presentation.
Yes, we
Yes, you
can.
can see.
All right, thank you. I will begin shortly. Right. Thank you, honorable members, for your time in allowing us to present on the draft gas bill. We are from Natural Justice. My name is Alan Basajasubi, and our presentation is really focused on a constructive and solutions-oriented review that is grounded in the Constitution, environmental law, and South Africa's climate change commitments. Now, we are here because we welcome the modernization of the regulatory framework, and our position is rather, as has been stated by CER, that we are really focused on the we are really focused on ensuring that the modernization, i.e. the licensing, the registration, inspection, and enforcement is strengthened within the bill itself, which is basically a strengthening of the 2001 Act. But our review is really benchmarked on against the Constitution, NEMA, the National Water Act, the National Air Quality Act, and the Climate Change Act. And our concern is rather that we would love to raise very proposed, minimal, and targeted amendments that do not seek a redraft of the bill in its form, but rather that entrench and ensure the provisions are legally grounded, are solutions oriented, and are justice centered. A lot of our focus is around environmental justice, climate justice, ecological sustainability, and ensuring that South Africa's domestic and international obligations are strengthened and observed within the bill itself. Now, we understand that within the bill's architecture, it has a very strong commercial engine focus. But upon further review, we observe that it's very thin on an environmental chassis, which is just a tongue-in-cheek comment on having a very strong, robust vehicle that has a strong commercial engine, but in terms of its foundational structure is very thin on environmental regulations and environmental governance. And so for us, it's really about embedding very robust environmental, climate, and community safeguards without repeatedly deferring them to other legislation and ensuring that there's a cohesive integration of the environmental governance frameworks within the bill itself. So the question for us is, it's a question of balance, right? It's a question of ensuring that there's a fixable minimal amendments without having to redesign the bill, but ensuring that the bill itself is strong and anchored in good environmental governance and justice. Now, within the overview of the gaps that we have noted, we will focus specifically for the presentation, although there are other gaps we have noted in our comments, we chose to focus on three fundamental structural gaps that drive most of our concerns. The first one is there seems to be a misalignment on climate governance. There's no climate compatibility assessment anywhere in the bill, which is not even integrated within the gas master plan, not institutionalized in the ministerial determinations, and not in the licensing provisions. So there's an overarching misalignment between the bill itself and the Climate Change Act, which governs the manner in which programs and sector development is to happen in accordance with South Africa's climate change commitments. The second gap that we see is that it creates parallel tracks problem. So although the bill cross-references NEMA in principle, it doesn't cross-reference or deal with any of the other environmental governance provisions, namely the Water Act and the Air Quality Amendment Act. And so we can see that the bill in its design provides for the granting of licenses before water use or air emission authorizations are secured, which already shows a misalignment with environmental governance. And the last structural gap that we have foreseen, that our comments really focus on, which has already been raised by our colleagues at CER, is that there is a procedural participation gap. There are objection standings which are very limited to those that are materially adversely affected, which limits the extension to which interested and affected parties can engage with some of the provisioning and licensing of these gas to power projects. And there are significant provisions, as has been stated in Section 33, where the issue around expropriation really marginally only deals with, does not deal significantly with land-based consultation. And so in those instances, the duties that are dealing with consultation, particularly with interested and affected parties, are thin and entirely absent, particularly on non-municipal land. Now, the other issue that we have with the bill is that when it comes to the concern around climate governance and LNG lock-in risk, we see that the mechanizations within the bill deals with licensing beyond 2030. And yet we understand that the process in which licenses are usually granted in 25-year increments. And we know that the IRP, which is the basis behind which energy planning is to be observed, identifies that by 2036, the gas begins declining, where we see battery and energy storage and wind ramping up, as well as solar. And in 2040, the IRP proposes that no new gas build is proposed beyond that point. And yet, if we're going with the 25-year term in which a lot of these gas license bill will be promulgated and passed, we will see that licenses will be still valid by 2052. This is obviously taking into consideration that if these projects are going to be developed within this period and forecasting what the IRP is stating, then these mechanisms and these infrastructure won't be generating any monetary benefit for the state or its citizens, and will become a sunken cost, which will then end up being passed on to the customers and the citizens by and large. And so for us, the infrastructure to build for 2030 security supply risk needs to be licensed or managed in a way that considers the IRP transition planning horizon, but also take into consideration our climate change commitments in terms of when we should be phasing away from oil and gas, for example. Now, the other gap, as I've mentioned in detail, is that there are insufficient gaps in which the issues around water, air quality, and cumulative impacts are not discussed in great detail or even engaged at all. In terms of the Water Act, pipelines, notably cross rivers and wetlands. LNG terminals need vast amounts of water for cooling and regasification, and yet the bill has no cross-reference to the National Water Act. A license can be granted before any water use license exists. And then in terms of the Air Quality Act, the LNG regasification is likely listed activity, which requires an atmospheric emissions license, but the bill does not require that before any operation license is issued. And then in terms of dealing with these cumulative impacts, clustered infrastructure, which has been identified around Kucha, Richards Bay, is assessed facility by facility, but nowhere in the mechanism are there provisions that deal with the cumulative impact assessment, which requires regional and cumulative assessment of combined impact. And so that seems to be a cascading issue that will once again form itself within the bill and will have misaligned points of contention with NEMA and other environmental governance acts. And then in terms of the third gap, which deals with land rights and community consent, Section 33, which deals with expropriation, and Section 35, which deals with servitude rights, leave most land affected by gas infrastructure without a clear notice or consultation right. So in Section 33, which deals with expropriation, it defers entirely to the Expropriation Act, which is still in process at the moment. But within that specific provision, there's no mention of notice, consultation, or engagement duty within the bill's own text. There's no reference to IPURA or free, prior, informed consent for traditional and indigenous communities, particularly in the context of those that have informal land rights. And even though the bill makes referral to the potential referral to the National House of Traditional Core and Sign Leaders, this is a parliamentary step. It's not a community right. And so there's a big constituency within the bill that is not protected and safeguarded within the provisionings around expropriation of land. The other section around land rights and community consent is around Section 35, which only covers streets, roads under municipal control, but it remains absent or quiet or omits to deal with issues around private agricultural and community land, which will most likely be the majority of pipeline routes. And it is clear not to engage with within the bill. And also when it deals with the Section 35, there's no notice of right or no route approval right or no guaranteed compensation mechanism that is entrenched within the bill itself. This leaves affected landowners and occupiers with the weakest procedural position within the whole bill. Then when it comes to the recommendations, our recommendations already align with some of the concerns that have been raised by the committee in previous meetings. When it comes to the issue around objections, land and compensation, and proportional penalties, our recommendation and submissions regards to Section 14 calls for a broadening standing to mirror NEMA's interested and affected parties test. And in regards to Section 33 and 35, adding a consultation duty within those provisions speaks to issues around land compensation, certainty, and standing for objections. Then when we regard environmental protection, there we are calling for integration with National Water Act and the National Air Quality Act authorizations within the gas licensing conditions. And then when we speak about household level access and energy justice, there we call for extending non-discrimination to prospective customers and affected communities, and entrenching or instilling a benefit sharing component or mechanism within the bill. And then again, repeated in terms of proportional penalties and local economic development and affordability. Again, we propose the institutionalization of a benefit sharing requirement and local content strengthening beyond the current wording in the bill itself. So what we ask for are rather 7 targeted minimal amendments. There are more that are in our comments, but I'll focus specifically within this particular oral proceedings. The first one is to explicitly empower the regulator to set and integrate water and air anemia conditions within the licensing conditions. The next one is to require climate compatibility assessment. So there we're asking for a clearer climate change alignment within the Gas Act, within the Gas Master Plan, excuse me, and ministerial determinations in ways these functions are to happen within the bill, and that the bill itself also align itself with the Climate Change Act and all the regulatory requirements thereof. We then ask for, with regards to consultation and procedural safeguards for communities and interested and affected parties, broader objection standing. So mirroring what NEMA says or quantifies as interested and affected parties. Then in terms of the issue around consultation with land specifically, we call for at least an insertion of notice and engagement requirements within section 33 and 35. And then with regards to strategic environmental assessment, we call on the bill to deal with a potentially inputting a mechanism around strategic environmental assessments within the structures of the Gas Master Plan, within the rubric that is already echoed under NEMA, section 27, subsection 5. And then when we talk about continuous rehabilitation, we are saying that we ask that section 34 is an obligation that is a standing obligation, not one that is only triggered on the exit of a particular project. So that this process is a continuous rehabilitation duty that is imposed on license applications. And lastly, we call on a more instrumentalization of the proposed methane monitoring power within the regulator to make rulemaking authority to prescribe methane measurement, assessment, reporting, and disclosure, which will form part of South Africa's greenhouse gas inventory gap monitoring reports. And this will again ensure transparency, particularly with industries like LNG and gas infrastructure, which produces a lot of methane. And so for us looking ahead, real issues that within the square arena of the parliamentary committee is really to ensure that the most substantive decisions within pricing logic, project prioritization, household access, although they are delegated within the gas bill, we ask for explicit climate compatibility criteria and scenario-based planning from the outset. And this is what the gas bill will empower in the development of the Gas Master Plan. We call for, mandatory parliamentary reporting on strategic integrated energy projects, and where there are exemptions that are granted or emergency determinations, that those Parliament maintain mandatory oversight over that, and where there are possible opportunities for public consultation on these exemptions and emergency determinations, that the public be brought into the confidence of the minister making such, and that reasons are published so that the public understands the manner in which these decisions are being made. And again, for us, it's really to anchor this infrastructure, this development pathway on the basis of sunset logic, carbon budgeting, and managing potential lock-in of long-lived fossil fuel and infrastructure, which remains consistent with the IRP's 2025 own post-2036 trajectory, and again, the Climate Change Act. And for us, I think it is to say that, if gas is to play a role in South Africa's energy system, it must do so only where it is demonstrably advances equity, resilience, and decarbonization, and one that's governed by a framework that is constitutionally coherent, climate compatible, transparent, participatory, and protective of communities and ecosystems. So we ask the committee respectfully to direct the department to respond formally to the climate, water, and community gaps identified today, to support targeted amendments set out in our written submission, and to keep the door open for continued engagement as the Gas Master Plan is developed. And that concludes my presentation. Thank you very much to the chairperson and the committee. Thank you.
Thank you so much to you, Mr. Webster. For the presentation, please stay on. The indulgence of the questions that can arrive after we've taken the other two presentations. So we'll then go on to LPGSA. The Cosette is put them on as co-hosts so that they can be able to slice their presentation. And then afterwards, we'll take questions.
LPGSA?
Yes, we hear.
Excellent. I'll give you co-hosting rights, ma'am.
Okay, thank you.
There we go.
Sharing. I just want to check, is my screen visible?
Yes, it is.
Okay,
Yes.
thank you. Good morning. Still morning. My name is Khadibulai Dishabi. I'm the Managing Director of LPGSA. Just to a brief introduction of who we are. We are a non-profit organization, 40 years old next year. And we are also an industry body that is dedicated to the safe use of LPG or LP gas throughout South Africa, helping users and operators understand the safety implications, but also do so by using LPG through safety compliance and best practices. Just to tell you a bit again, we have run on a mandate from the Department of Employment and Labor for cylinder verification and appliances verification. What does that mean? It means all the appliances and the cylinders of LPG imported or manufactured in the country needs to be permitted, and the Department of Employment and Labor has given that responsibility to LPGSA. But also through SAQCC Gas, we train and register all the gas installers, technicians, practitioners, whichever word you use, on installing gas safely through all the scopes, which is domestic, commercial, and industrial applications. We don't just end there. We support the Department of Mineral Resources and Energy, or DNPR, and the Department of Electricity and Energy with the rollout strategies and the clean cooking objectives. We assist and we do so actively in promoting the benefits of LPG, promoting it as a cleaner and safer energy source for the country. We conduct throughout the country education programs for consumers so that they can use LPG safely in their homes without complications. And we also actively work on impacting the drive for demand for LPG. We don't also end there. We support the Department of Employment and Labor, the Fire Department, and some law enforcement with regards to compliance in terms of inspections and incidents investigations during LPG incidents that happen in the country. That's us in a nutshell. Just to give a brief view of LPG value chain. So I think everybody may know in this room that LPG is actually coming from either crude or natural gas. It's a byproduct of either of the two. And that is one message that unfortunately we consistently have to continue explaining, and that's what brought us into this room. This is an LPG value chain as you see it. It's either imported or refined. When South Africa had good refining capacity before, I guess, COVID, we majority of our LPG was being refined through those refineries. But we all know that we used to have during this time of the year of winter LPG shortages in the country, and there was concerted effort to ensure that there is import facilities available in the country. Hence, we saw the Richards Bay terminal being built and commissioned to cater for imports. Currently, majority of our imports of our LPG from the country, about 80 to 85% is imported, and is imported through the various ports that we have, but also it's imported. I think majority of it, no, I know majority of it is imported from the US. If you make deduction, you can say majority of our LPG that we use in South Africa is from natural gas or shale gas, being that from US. It then run through our wholesale divisions where it gets sold to different markets, could be in the bulk distribution, could be directly to end users. This is done by all the LPG marketers in the countries. Up until such time it gets to the end user, which is either yourselves, businesses, or industries. In a nutshell, sorry. Why we are here today, when we saw the gas bill coming, originally we understood that it may just be drawn or re-evaluated to address issues of LNG. However, on second read, we realized that it is creating a uncertainty and concerns for the LPG market. Just from the onset, on the definition itself, where the definition proposed that LPG is somewhat included in the bill, but it is included in a certain form, which is a regasified form. I think what the definition mentions is it's all hydrocarbon gases, including natural gas, artificial gas, hydrogen-rich gas, but then it gets to the point where it says regasified liquefied petroleum gas. We have a problem with that definition, as it it's actually denoting or saying that LPG should be included in the gas bill in a certain form, which is, I guess, regasified form. There is a problem with that. LPG is stored, is transported in a liquid form. It is only ever gasified or vaporized on usage. So the LPG that comes out of your cylinder in your home or in the restaurants, that's the part of LPG that is vaporized or that is gasified. So to us, already there's a concern with the intention of this bill. Is it intending to regulate LPG at home point during the use in my house or in your house or in the business? And how does it suggest to do that? Whereas it ignores the rest of the element of the value chain from when it's imported all the way it gets to my house or while it's in a cylinder. So that is number one concern that needed to be clarified. Was it the intention of this bill to regulate or to put into regulations LPG through the Gas Act or not? Perhaps maybe we should just mention that the original or the previous gas bill explicitly excluded LPG because there it spoke about piped gas. In South Africa, LPG is really delivered and transported to homes in cylinders, packed in cylinders, not in pipelines. So we understood from that perspective that LPG was excluded from the Act. I just wanted to also put your attention that one of the issues that we always grapple with as an LPG industry is when the interpretation is not correct. It introduces issues of legal interpretations where people tend to use words, and we spend a lot of time trying to express or to defend whether LPG in a certain format is regulated or not. And this bill definitely, I think, widened the opportunities for legal interpretation of whether LPG should or will be regulated through this bill, through the Act, the Gas Act itself. But also the fact that you are excluding the liquefied state of LPG will also then bring problems into that legal interpretation itself. I still grapple with the understanding of how are you going to regulate the LPG that is in the cylinder in my house when I start using it, when you ignored the rest of the time when it was stored, transported, and distributed and traded in a liquid form, which is where I assume matters the most. But also practically and industry interpretation as well. Like we said, when you ignore the liquid form and you only consider the gaseous form of LPG, how are you going to put in effect all the pricing mechanism? How are you going to put in effect all the, I guess, the BEE requirements, which applies mainly to businesses rather than to me as an individual? So those are some of the concerns that that we bring in forward. I'm not gonna really waste your time on regulatory consideration, because I think as regulators, it will be clear that you bring in the I don't want to use wrong words, bring in the interpretation, or bring in the issues of interpretation, what implications they will have on regulatory elements of the LPG. But the other thing that we have noted is that a lot of powers around the regulatory framework of the gas sector will be given through gas master plan. We just wanted you to note that historically, gas master plan has never considered LPG and its development in this country. So it is important when you decide whether or not this bill on the Gas Act should include LPG, it should be considered all the way to the gas master plan. So that is part of that. So for us, why we came here, we basically saying we need clarity on the intended regulatory treatment of LPG under the gas bill, and to ensure that we do not provide legal and regulatory uncertainty across the industry. But also, when you do so, ensure that the gas master plan is so thoroughly also instructed to take into account the LPG, the existence of LPG in South Africa, and the role it plays on the energy distribution and energy availability and security of this country. I'll stop there. Thank you very much.
Thank you for that presentation. We will then speak on Russell. Please do stay on for the participations after Russell's presentation. If you could say, please stay something in the table.
Sasol is on the platform, Chair. Mr. Kosef will lead the presentation.
Thank you, Mr. Kutzer. Do you need me to share from my side?
Yes, please. I gave you co-hosting rights, eh?
Perfect. Thank you very much. I'm just
Sure.
going to pull up many thanks to the committee. Just for reference, I'm Jack Kosef. I'm the Senior Manager for Stakeholder Relations, Policy and Advocacy for our business building function, which includes the gas business. So very, very obviously very pleased to be in a position to share this particular set of comments with you. We'll be very, very brief and to the point. I think this should come up now. Can the committee see the presentation?
Yes.
Okay, marvelous. I'll continue. I'm just going to also... So for the benefit of the committee, I think we want to start with a very straightforward set of comments. Firstly, SASOL strongly supports the objective behind the bill, repealing the Gas Act, establishing a modern regulatory framework, and really looking at ways that legislation can help the commercial market here, and a very important commercial market, by facilitating investment, ensuring security of supply, and really making sure that as South Africa's gas market enters a new era, we are able to secure its orderly development. We do want to make sure that the regulatory framework that is put forward, and we do believe that we speak for not only SASOL itself, but our wider 300 gas customers to a certain extent, and the wider universe of gas-dependent industries that we operate within. It's going to be important that the framework enables continuity of supply, investment certainty, and a fair transition to liquefied natural gas as the next phase of South Africa's gas supply reality. We do recognize the bill has made progress since the NEDLAC phase on a number of issues that we raised as part of the team that was representing BUSA. There are, however, some issues we feel that are still a problem for investment certainty, which is important because certainly for the purposes of the gas market, the key infrastructure deployment is going to depend quite heavily on private investment. And we believe that there are issues under the bill as drafted that would make that slightly less likely than it should be. And that's part of why we want to ensure that the committee takes this into account when looking at the bill. What we would say is also that there are some missing pieces in terms of how the bill seeks to set out the new market architecture. So while it broadens the regulatory framework beyond pipe gas to accommodate LNG and future gas, it doesn't yet provide the high-level overview of a market framework for all the things that go with that. Multiple shippers, multi-product gas markets, etc., are not necessarily allowed for. To some extent, we can make the argument this can be allowed for in regulations, but there is an extent to which it needs to be defined at the level of legislation. I'll go into that in a little bit more detail in a moment. Just as an example on that one, the bill enables and allows for multiple market participants, but doesn't establish the rules that are required to govern things like capacity booking in terminals. And without these principles, open access exists theoretically, but not in practical terms. So these are just specific areas that we felt needed to be specified. Okay, just to quickly, where we have skin in the game. I think this will be known to the committee and to the audience, but it's worth restating. Firstly, we operate across the gas value chain. We have an upstream sourcing via our Pundi and Tamani fields in Mozambique. We are a shareholder in Romco and have operatorship of the transmission and pipelines under it. We have a gas trading business, obviously a gas to liquids business, and we have participated as a potential supplier in the gas to power universe as well. And we also run our own gas to power operations for a certain portion of our internal electron needs. So SASOL is very clearly heavily involved in the question of how the gas market evolves. We obviously have a pronounced interest, which we've made very public, in not only the bridge to the LNG era via methane-rich gas, which we have committed that we can basically provide from 2028 to 2030, but post that there is the question of LNG importation. So LNG importation and regasification is a huge area of novel capacity requirement in the Southern African context. We have been very clear that we believe that the that will have to come from importation initially from the Mozambican coast, but obviously there are large questions this bill must deal with around how LNG importation into South African terminals will function. Then clearly we have an interest in pipeline and transmission, and in the continuation of gas trading and supply. We do believe regulatory predictability is important, along with institutional clarity, and to ensure that cost-reflective and fair pricing regimes are maintained as new gas approaches and new gas supply modalities come online. Okay, some quick general observations. These do not need much work, because this is just where we feel that the bill is done well. Firstly, the idea that there is a comprehensive framework for regulating tariffs and maximum prices is useful. The provision for the development and review of the GMP is also welcomed. There's definitely improved definitions, including the treatment of excessive pricing. And we do believe the recognition of the concurrent jurisdiction between the energy regulator as NERSA and the Competition Commission is constructive, because there has been a fair amount of grey area historically, and a lot of it, as the committee is aware, has had to be resolved via litigation. So obviously much more preferable for it to be resolved via legislation, and that is exactly what the bill seeks to do. There are still structural features that may undermine investment certainty and could increase regulatory risk. So we're just going to list them off quickly. Firstly, ministerial discretion is understood as an expedient and is something that we are seeking to introduce in legislation to prevent deadlock and to really make sure that fast tracking of decisions can be taken. However, the danger is that creating the ability for the ministry and the ministers specifically, whoever it may be, to take licensing and policy determinations under a wide discretionary ambit without transparent time-bound processes and without published reasons creates the risk that you introduce opacity into the decision making. You put a screen in front of the way decisions are made, and it could create a level of uncertainty that we feel is problematic. We'll give you a view as to what we will do about this in a moment. Then, while we praise the concurrent jurisdiction, there is between ComCom and the regulator, that this now actually requires a framework for coordination, sequencing, dispute resolution, and then avoiding the risk of duplication, inconsistent outcomes, and delays. So the recognition of concurrent jurisdiction is important, but a framework to manage it is not quite there. Then there isn't at this stage a clear tariff setting methodology. This has been, as I'm sure the committee will be very well aware, one of the major points of contest in litigation over this last period of the previous act is what is a fair element of cost recovery to include in the gas investors' recovery price and within the context of maximum gas prices. So there is this clarity is still not quite there. So the fact that it's improved doesn't get it all the way to where we feel it needs to be. And again, we'll give a view on that, how we feel that could be dealt with in the moment. So the master plan timelines, it's very good that the master plan receives formal recognition, but it does not have a required publication sequence. There isn't a real penalty as to what happens if it's not published. So relying on it as an instrument for policy certainty is compromised by the fact that there is no constraint and no set of accountabilities placed on the department to deliver it at certain times and within certain boundaries, as there is, for example, with something like the IRP. Then the administrative penalties, the structural separation, administrative penalty, and the regulated dual role, these are slightly more technical questions. Let me just go through them very, very quickly. So the structural separation question is that it really just, it's more an issue that it introduces administrative burden. So the idea that there needs to be separate management, accounting, and data structures across the different pieces of the value chain create a level of burden on integrated operators. It's not a fatal flaw in the bill, but it does add friction when what you're trying to do is to expedite investment. So where operators do function in an integrated fashion, and this will be the case across different parts of the way gas works, across pipelines and sourcing, pipelines, transmission, distribution. The structural separation of management does seem to be overkill from our point of view. Then the administrative penalties is understood, and this is obviously a logical inclusion in the context of the gas bill, but the fines that are linked to turnover without a proportionality framework create uncertainty and will likely introduce the perception that the fines could fatally erode the business case for investment into gas infrastructure, where non-compliance is technical or administrative as opposed to malicious in nature, for example. So we do feel there needs to be a proportionality framework included. Then the energy regulator, and this is also linked to this question of the need for a framework of interaction between the ComCom and NERSA on this. So NERSA then retains both an investigative and adjudicative function over excessive pricing and discrimination. So there's a referee-player problem, as it's often referred to in a more political context, and in a commercial context, where NERSA is both the investigator and the adjudicator of excessive pricing and discrimination claims. Some quick proposed safeguards. We would introduce mandatory, transparent, and time-bound licensing requirements, including with clear public consultation requirements. We would establish a clear statutory framework governing the coordination between the Energy Council and the ComCom. We would provide guiding principles. We do not presume to stipulate what those could be. We can obviously offer that we can offer that proposed guidance at the committee's request, but we would suggest that there need to be clear guiding principles, including recognition of the cost of capital and reasonable return on investment included in tariff setting. We would suggest that the master plan requirements include defined timelines and there be accountability mechanisms in the case where the department fails to publish. We would reconsider or provide flexibility on the structural separation requirements, and we would introduce proportionate and tiered administrative penalty framework. Finally, we would suggest that there should be an independent review or appeals mechanism for regulatory investigations and determinations. The final conclusion on this, if concerns are not addressed, the risk could be reduced investment in LNG and gas infrastructure at exactly the time when we need to be increasing it. And there could be delays in project development from overlapping institutional mandates. There could be reduced competitiveness of gas from a pricing intervention risk and the risk of deterring new entrants. And that would obviously undermine the role that gas is set to play in our energy sovereignty, energy security, and in our industrial development. Finally, we thank the committee. We reiterate our support for the objectives of the bill. We are not in any way seeking to undermine this bill. We think it's very important. We do believe that there are further refinements needed so that this bill supports long-term investment, infrastructure development, security of supply. And we will remain committed to constructive engagement in finalising the legislation, and we remain at the committee and indeed at Parliament and government's disposal. Thank you very much.
Thank you for the presentation, my person. We are then going to take clarity-seeking questions on all the presentations that we have seen. Honourable members. Honourable Hassan.
Thanks very much, Chair. Sorry, I just have to swap over to a different Wi-Fi. I'm going to turn on my camera as a result of that. But it's actually, I think, to natural justice. I was just making a few notes while they were speaking, and I was interested in their thoughts around appeals processes and challenges. I hear what they're saying around the links to the climate change bill, et cetera, and some of those environmental issues. But one of the problems we are having across the board is the backlog with the NEMA appeals. And that's because all the appeal processes are set within NEMA. So if you look at critical minerals, if you look at shale gas, I mean, all those other things, in addition to what we are looking at here, gas, are sitting in a real backlog there. And that doesn't really help anybody. It doesn't help environmentalists. It doesn't help business. It doesn't help the economy. It doesn't even help us as parliamentarians because we are unable to process things at a pace at which we should. So I'm just interested in Alan's thoughts around that, how you suggest we deal with backlogs and appeals, particularly regarding climate change and environmental issues, and how we can manage that. Because I'm just worried if we keep putting things towards NEMA, we are going to experience exactly what we are now. And that means that we are unable to move forward, especially given some of the time constraints on this issue around the gas cliff. The gas cliff is a hard deadline. If a NEMA backlog stops us, it means that we're going to be unable to provide some form of LNG gas to the country as a whole. And that can really be critical negatively to the economy, but also to ordinary people who need or use some element of gas for heating, for cooking, etc., etc. So I'm just interested in thoughts there. Otherwise, just taking notes and trying to capture everything that our stakeholders and the public are putting forward today. Thank you.
Thank you for your question, Honorable Hassan, which is a very good question. On one which I think has been broadly debated, quite robustly within our media context. But with all due respect, a starting point needs to be what the Constitution envisages. So we are a constitutional democracy. And Section 24, which is the right to a healthy and meaningful environment, sets out the requirements that are placed on decision makers when considering development. This was also supported and confirmed by the Constitutional Court in fuel retailers when it describes what sustainable development looks like. It's not just sustainable development for the sake of it. It has to be ecologically sound as well. And I think one of the premises that needs to be placed very squarely within the debate is that we need to engage with the question around what is not only sustainable development, but what is ecologically sustainable. And that needs to factor in and weigh up the principles that NEEM envisages, which is what gives effect to Section 24. And so within the context of the debates that are happening with appeals that are being taken to court, the fundamental question isn't that communities are against development. It's rather that the decisions that are being taken are not balancing what the Constitution requires decision makers to factor in. And so the question then becomes not one of stopping development, but rather one of making sure that decisions are equally balanced and governed by the laws that are governed by the Constitution, fundamentally NEMA. And that is all that is being said with this gas bill as well, is that fundamentally there's no opposition towards it, but it needs to ensure and secure the rights that are enshrined by the Constitution. Further to that, the Climate Change Act, which gives effect to South Africa's constitutional obligations that are enshrined in Section 39, is that the Act itself in Section 7.1 says that any program or any mechanism that is to be developed by the other departments needs to be holistically coherent with the Climate Change Act, which regulates the impacts of climate change, which are being broadly felt by the people of South Africa. And so all that we are asking of decision makers is to ensure this whole of society approach to addressing climate change, which the president has addressed through the PCCE, and through the fundamental mechanisms that are enshrined within government institutions. And all we're saying is instead of ensuring that there are governance gaps between various departments that are not acting incongruent with one another, there needs to be an alignment between the different departments. And as it stands at the moment, this gas bill is not coherent and aligned with what the climate change says. And the Climate Change Act, just as NEMA, governs all the other acts that regard to environmental governance. And the bill, given its foundations on constructing and licensing within the environmental context, will have an impact on environmental rights. And so there needs to be a necessity to ensure that people whose fundamental rights are going to be impacted have the opportunity to appeal the decision, have an opportunity to contest where they feel they haven't been given opportunity to raise their concerns, and to have valid issues addressed by the decision maker. And so that is the question of the quality of decision making, not the problem of the actual act in question. And so I think those debates are going to continue. And I think for us, the focus should be, let's secure sound governance by ensuring that the governance framework as enshrined by the Constitution is followed, not for the sake of just doing development, but ensuring that it's sustainable and that it's ecologically fair with regards to the Constitution and environmental obligations that are placed on decision makers. So I'm not sure if that answers your question in entirety, Honorable Hassan, but I think that just forms the basis of our premise in terms of how we see this bill acting in a way that must not continue incoherence, but should rather build a whole of society approach, and one that is, aligned with the other departments in regards to their constitutional and statutory obligations. Yeah, thank you.
Thank you. I just decided not to interrupt you there as you began to respond. I was still going to seek further clarification questions if there are any. But we appreciate your response. I don't know if there are any other questions from other members from the three presentations they received.
Chair, through you, quick follow-up, if you'll allow.
Yeah, because there are no further questions, we'll just take that one and then take the question.
May I go ahead, Chair?
Yes.
Okay, thank you. Sorry, yes. I just wanted to, because I think the point I was trying to understand, I think we've missed each other, Alan. I think we're all in agreement that there must be concurrence between the climate change legislation and the constitutional frameworks. We're all agreeing on that, and that development must never be at the cost of communities. I think that's a basic minimum we all completely agree on. I'm asking a more particular question because we have an opportunity here, because we are redoing the gas bill, to learn from the mistakes of NEMA. And I'm saying one of those challenges has been the backlog of processes of appeals and challenges, whether it's by communities, whether it's by business, whether it's by an ordinary citizen, etc., etc. I'm interested in the views of natural justice about how we close that gap. What do we need to put in this particular piece of legislation, or what's recommended, so that we can have a better sort of appeals process and challenges process, because that is something we're having challenges on the other side. So that was more my concern, less the issue around development versus the environment. I think that's where we miss each other. That's not the topic here, if that makes sense, right? We agree that the environment must be paramount at the same time, so is development, and those two things can in fact work hand in hand with each other. So I think that's a basic understanding we all have. I'm just interested in the possible appeals process and the thoughts there, so that we don't make the same mistakes as the current legislation. Thank you.
Thanks, Honorable Hassan. Yeah, thanks for clarifying that. Glad we're on that same page. I think for me, the question becomes ensuring that there isn't a parallel procedural sort of mechanism that is being institutionalized within the gas bill, which is different to the other overarching environmental governance framework. So there's no need to reinvent the wheel. It's rather to align the environmental governance mechanisms that are enshrined in the other environmental governance within the bill itself. Because at the moment, what seems to appear is that it's creating a parallel track between those ones that are already established in NEMA, et cetera, and where they are, missing in the gas bill. So we have a place where there is a gap in terms of the guidance into how environmental aspects need to be factored into the decision making. So all I'm really saying is perhaps there just needs to be a thinking around the language, the architecture of the gas bill, and how it reads in alignment with the other governing provisions that are already enacted and already operating. So I think it's just sort of connecting the dots and ensuring there's a refinement of a sort of guidance on the application of discretion or decision making in a way that speaks to the form and principles of what is considered important to factor in an environmental context. And so I don't think there's a need to make a separate clause. Perhaps it's just to refine the specific licensing mechanisms and procedure within the bill that factors in environmental factors that need to be factored into the decision-making process, and to ensure consistency, to mirror the same administrative justice principles within the bill. So if there are any aspects missing on, appeals and reasons for decisions and the opportunity for a decision to be taken on review, etc., that just needs to be factored within the architecture and language of the bill. That to me seems to be unclear, and I think that's where there's an opportunity to refine that a bit more and make it more clear within the bill. But it doesn't need to reinvent the wheel per se. I think it just needs to borrow from the other sort of legislative schemes where dealing with development, they have integrated environmental principles and factors within the provisions governing decision making. So I think that would be, a first start, is to build that into the bill itself, because that is a component that I think is currently missing, or rather not very clear in its architecture. That will, I think, avoid potential appeals down the line where there isn't any guidance to decision makers on what kind of factors need to be engaged with when making decisions that are going to have environmental implications. Yeah, hopefully that answers your question.
Thank you so much. So with that, we are going to then go to the lunch break, which would have initially been 1:15, but since we're going to go now at 4:30, we would have wanted it to be 45 minutes. So I think we will then come back at 1:15. Please, Mr. Kodze, request the speakers and alert them of the time changes so that at 1:15 we begin to take the first presentation and the others follow suit with the 20 minutes allocated to each person, to each stakeholder to present, and then we take the clarity seeking questions afterwards. So with that, we can even remain online and then come back exactly at 1:15 for us to wrap up. Thank you so much for your participation in the first half of our program.
Recording stopped.
And it is time for us to resume with our program, as we had agreed before breaking, that we would come back at 1:15 so that we can continue with our program. So we have 4 outstanding presentations for today, which is from South African Oil and Gas Association, African International Advisors, NERSA, and Groundwork. And then afterwards, we'll get clarification questions. So from all the 4 stakeholders that we present, please do note that afterwards, members will be accorded a chance to ask questions on your presentations. So please do afford the time to stay on even beyond your presentation, so that if there are any questions that are directed to your particular presentation, you are able to give the clarity. We just want to make a reminder that it's not an engagement or deliberations. It's just clarity seeking questions, because the 18th is the day that has been set for actual engagements, after the department has also gotten a chance to respond to these presentations that you're receiving today. So we are then going to take the first presentation that we don't have any further waste of time from the South African Oil and Gas Association. Mr. Kotze is the representative ready.
Mr. Adrian Strydom, Chair, is the Sauga representative. And Mr. Strydom, you've been given co-hosting rights if you want to project your presentation, sir.
Thank you, Chair. Thank you. Good morning. Sorry, afternoon. Honorable members, guests, participants. Thank you for the opportunity to present. I will be sharing.
Recording in progress.
You can proceed.
Is my presentation visible?
Yes, it is.
Thank you. So, ladies and gentlemen, again, thank you very much for this opportunity. If we look at the South African Oil and Gas Alliance, I'm saying this because I just want to alert the honourable members to the fact that we're representing a broad base of industry players across the value chain of oil and gas. We have a proud collective voice for the industry over the past 23 years. We've engaged with government, industry networking platforms. We arrange events, networking events, industry trade missions. We are also a joint action group registered with the DTIC. So the purpose and public value test is very important in this presentation. This submission consolidates the key issues, recommendations, and policy proposals raised by stakeholders on the gas bill. We have engaged stakeholders, and we certainly have received several inputs from stakeholders. Essentially, 2 very important points. There is a broad support for replacing the Gas Act of 2001 with a modern regulatory framework. The central question is whether the bill, as refined, can translate that framework into energy security, because energy security is an important issue as South Africans, we need to bear in mind. So the central question is whether the bill is refined and can translate that framework into energy security. And if it can make South Africa attractive for investors. So it is important that we look at the whole issue systemically. So a framework is required to serve as a shared decision lens to connect policy, regulation, infrastructure, markets, and public value. So it's not just a standalone legislation, but it should be interlinked. So rather than as a substitute for the statutory roles of Parliament, the minister, the energy regulator, or other institutions, it is a systemic environment that we are requesting. So, Honourable Chair, just briefly then, what the bill gets right in our views and from the views that we got from our stakeholders, modernization of the gas regulatory framework. So we certainly do require a renewed and fresh look at the regulatory framework to prepare ourselves better for the future. So the replacement of this act is important, and other recommendations. So there are certain areas where the bill certainly is hitting the mark. There are measures to promote infrastructure, stronger enforcement and compliance tools, and we have an increased opportunity for private-public collaboration, and that's important if we want to optimize engaging with industry and government and moving this country forward. Greater recognition of private sector investment in developing the gas market. So those are some of the positives that we are seeing. There are, however, some areas that need work on. So clearly, we need to clearly distinguish between, my screen is a little bit cluttered here, so let me just try and move this here. So we have to distinguish between policy and delivery. Licensing decisions should be administered independently, preferably by the energy regulator. That's why they're there. We have to reduce uncertainty arising from excessive regulatory discretion. So there has to be regulatory certainty, and for investors to be drawn into the sector, we need that certainty. Clarify the scope and the limits of ministerial intervention, establish key commercial and regulatory principles in legislation rather than deferring them entirely to a future regulation. So there's some more work needed in the area of regulatory certainty. Then in the area of environmental authorization and appeals, honorary members, chairperson, participants, there are some challenges. We need to clarify environmental authorization requirements for different project categories, because the environmental requirements are different for different situations and for different types of initiatives. So we need to clarify those. our members and stakeholders felt there should be an improved guidance initiative on stakeholder consultation and public participation so that we know what we're dealing with as an industry. And some thought needs to go into clarifying stakeholder consultation, what's meant by that, so that we do not end up in unnecessary court cases that doesn't help the situation and promote investment into the industry. We need to accelerate appeals affecting strategic energy projects, consider specialist appeal mechanisms with relevant technical expertise, and to reduce unnecessary delays while maintaining robust environmental protection. We're not saying do away with environmental assessments and protections. We are saying let's work together to make this industry work for us. And ladies and gentlemen, my colleague, convener of the gas leadership team, will come on after me and do a brief presentation as well. But Craig Morkel. So just to say that we can see that every oil crisis in history shook the world. And Africa isn't immune to the kind of challenges one suffers as a result of a crisis that shake the world. And we need to make sure then, therefore, that we are more self-sufficient in terms of energy and energy provision, supply of energy. And gas is certainly one of those very important. In fact, the Europeans declared gas a transitional fuel, but in Africa, we need to see gas as an enabling fuel. We need manufacturing. We need to make sure that we proceed and develop and build this country. We need employment creation. And gas can be that game changer. So domestic gas exploration is therefore an important consideration. And we need to finalize and implement the gas master plan as a matter of priority, align the gas bill, gas master plan, the IRP, national infrastructure planning initiatives, so that we look at this in an integrated way and improve policy certainty for exploration and production activities in oil and gas in particular against this background. We need to address regulatory bottlenecks, that there may be, accelerate appeals and administrative processes that delay development, strengthen collaboration across the relevant government departments involved in energy development. I'm not going to stay with this slide, but it's clear that Africa feels the impact of energy challenges in every part of the economy, and it's important to take that into consideration. We need to, in the Act, see facilitation of strategic infrastructure development, and our members feel that not sufficient emphasis is placed on that. A coordinated approach, consider a single window facilitation mechanism for nationally important infrastructure, where it makes it easier to engage across the sectors, allow regulators and state authorities to process approvals in parallel where practical. So several of these infrastructure related recommendations were made. project bankability. Can everybody? It seems like I've got a challenge with sound, but I'll try and continue. So legislation should explicitly support the financeability factor, the infrastructure finances, predictable approval timelines, long-term investment certainty is important. So that should come out in the legislation to make sure that bankability is improved. And then tariffs pricing is important. It's important to include guiding tariff and pricing information and considerations. And then LNG, it's great that liquid natural gas supplies is being considered. And then some municipal approval intervention may be needed. It takes a long time sometimes to get municipal approvals, and there should be a standardized municipal approval process in place, and the legislation should make room for that. Enabling private infrastructure development. There's certainly is strong support from our members and stakeholders for provisions along certain categories of gas infrastructure, including storage, trading facilities, to proceed without requiring additional ministerial determinations. It is no secret, ladies and gentlemen, that energy drives manufacturing, and we should never leave that out of sight. We need to build energy security. We need to develop an energy secure country to make sure that supply of energy is adequate. Interesting slide that I came across is there's a very, very strong correlation between energy-rich countries and well-being of the economic growth. So, in fact, a statement is made, no such a thing as a low-energy rich country. And therefore, I cannot motivate more strongly that we need to pursue local and make it easy for local gas developments to proceed in South Africa. If we look at our unemployment rates, I don't think it's a secret that we're not doing well. And then, ladies and gentlemen, youth unemployment is a crisis. If we do not deal with youth unemployment effectively, we are going to have challenges going forward, and we cannot develop and grow our future and go into the future. So it's important for youth development purposes to increase employment creation. You can see for yourself that we are the highest among those reflected on the slide, 62.4% youth unemployment. So, ladies and gentlemen, my bit, let me pause here and then possibly ask my colleague, convener of the gas leadership team, to do his brief presentation as well. So a workable gas bill, ladies and gentlemen, should create a condition for energy security, investment, infrastructure, market development, manufacturing, jobs, and public value. Thank you very much.
Thanks. Just before your colleague comes in, how much time left, Mr. Kotze?
Let's see.
How much time left?
3, Chair.
3 minutes.
Yes, Chair.
Okay. I just wanted the next colleague to know the time that they have. Can we proceed?
So, sorry, Mr. Mokel, you've got 3 minutes left. Sorry.
Minutes left.
No problem. I only need 2 minutes. Thank you to the members of parliament. Very quickly, there is a understanding conventionally that we draft policy, legislation, regulations, and then after that we do master planning, and then after that we do procurement. I want to share with you, it's become our contention that there's a missing link between master plans and that is market and suppliers and getting the economy going. But it doesn't start. How we move from a market and yet
You're breaking, Mr. Mokel.
in the electricity regulation in that not only procure the downstream energy facility, but also the interdependent infrastructure. So we're not even only dealing with energy, we're dealing with ports, we're dealing with rail, we're dealing with pipelines, we're dealing with the grid. And there seems to be a lack of coordination. And the Department of Electricity and Energy has started an initiative in the Northern Cape with district energy councils that we believe could become the vehicle through which stakeholder engagement and market formation in particular could happen, where suppliers and job seekers and developers and financiers and governments, local, provincial and national, get together in a whole of government, whole of society approach and define what the baseline of a project should be. When I say the baseline, we're saying how many quantities of X material is required isn't something that a procurement officer always knows. And so the idea is to use that opportunity to get the bidders together to help the procurer define the technical and other specifications of a tender and then to move forward. We haven't done that, and there is an opportunity to do that now, and we will report back further on progress in the Eastern Cape, where we will be doing something similar in the Sarah Baartman municipality with the blessing of the Premier, because we serve on the Premier's Investment Council. Chair, thank you very much for the time. Overrun.
Thank you so much for the presentation. As an oil and gas association, please do stay on for any potential questions that may arise from honorable members. We now move on to African international advisors.
Thank you, Chair. Sorry, Secretary, you wanted to come in?
No, it's fine. I gave this, what you will call the co-hosting rights, so if you want to project.
Thank you very much. Thank you, Chair. And thank you, Secretary. I'm busy sharing now. I just want to check if everyone can, if my presentation is visible.
Yes.
Thank you. Thank you. And firstly, thank you, Chair, and thank you, honourable members, for the opportunity to present. I will be quite brief and maybe just a quick word of introduction. We're a consultancy, Africa International Advisors. We've done work across many jurisdictions in Southern Africa on gas-related matters. We did the SADC gas, regional gas master plan, and we act for a number of players in the industry. So our comments is really based on our experience of this market and how gas markets work across the region, as well as inputs from some of the clients that we serve. I think many of the aspects of the bill have been quite extensively discussed today. So we have submitted quite detailed written comments. I'm not going to go into all our comments in this presentation. We really want to focus on two aspects. I also just want to echo the presentation by the South African Oil and Gas Alliance around, there are many things to commend in this bill. And as has been stated, it does serve to update and modernize, the regulatory framework for the industry. And I think that's really important given the changes that the industry is going through. So, some of the comments we raise should not be seen as overly critical of the bill. We do see many positive aspects, but I think there are one or two areas that we do want to highlight that are of concern. I think the first point that we really want to make, and we do want to start by providing the overall context, and this is an issue that has been raised, I know, in many presentations to this committee over the last couple of years, but South Africa is facing a significant challenge around securing gas supply. That I think is very well known and was also highlighted by the previous speakers today. But I think what is really critical to emphasize is that addressing that challenge is going to need significant investment, and it's going to need particularly foreign investors and private sector investors to take risk to make that investment. In two aspects. Firstly, obviously, we want to develop our own domestic gas resources, of which there are quite substantial resources off the coast of South Africa, as well as inland, as well as regional resources. And that's going to need it's going to need private capital to take that risk. But unfortunately, the timing of those domestic resources will not be sufficient. They cannot be brought online quickly enough to meet the supply challenges that we have as a country. And that's really illustrated in this slide, that we are facing a supply gap that can only be met through the importation of liquefied natural gas. And we,
recording stopped.
The committee is very well aware of
Recording in progress.
The developments at Richards Bay, for instance, as well as other regional LNG import facilities that are being developed. And this is a very different industry. It's a very different market from the one that we as South Africa are used to. South African companies have not traditionally played in the liquefied natural gas space, and none of our SOEs or SOCs have experience in both the purchase, importation, and storage and distribution of liquefied natural gas. Although obviously we do have companies that have done that for pipeline gas, and that industry is very different. So I think there are two aspects that I'd ask members to consider as you consider this bill. Really, the need for private sector capital to be mobilized to address our gas supply challenge, and then the very different nature of the industry that we will be having in the next decade and a half. And so within that context that we want to just highlight two aspects of the bill that we think need to be really considered, because they do create a great deal of uncertainty that could potentially act as a deterrent to investment. The first is Section 28(4) in particular, where it's providing the minister with significant discretion to identify players that would make investment in the gas supply and importation sector, and particularly to actually effectively potentially exclude the participation of private sector players in parts of that value chain. And we think that could create considerable concern amongst potential investors that are having to take long-term risks and make long-term investments, that they may be shut out of parts of the value chain through these provisions. And we've, in our written submission, we've provided detailed recommendations as to how some of these uncertainties can be negated. We obviously understand that the state has an important role to play in this value chain, and it would be important that the minister be able to facilitate that participation. But we do feel that it's quite important that the conditions under which that occurs need to be very carefully circumscribed so that it provides the certainty for investors around what the lay of the land is and what the playing field looks like. The second area that we think needs to be carefully considered is really Section 2810, which effectively requires the minister to approve, or NERSA, in fact, sorry, to approve a ministerial determination for any expansion or addition to any existing facilities. And we think that really needs some reconsideration, as we think it's unnecessary, that it can slow the process down, and what you want is investors to respond quickly to changes in the market, particularly if we look at the very significant growth that we expect in gas demand in South Africa, and also particularly in power demand and its related impact on gas supply. And so you'd want South Africa's facilities that would be looking to produce and import gas to be able to respond quickly to market signals and not have to wait for ministerial determinations to do that. So in terms of Section 28 and 29, we think these are two aspects that we think do need some careful consideration and improvement. Maybe just to make the point, which I'll make a bit later again, I think overall Sections 28 and 29, where it's providing for the minister to issue these determinations to enable the development of gas infrastructure are important and really good additions and good inputs into the bill. But really these two sections or subsections, we would ask that these need to be reconsidered. The second aspect that we would like to highlight is really Section 18, and particularly Section 18D, which really speaks to third-party access. Once again, we fully understand the need and for provisions which allow for third-party access to strategic infrastructure to be facilitated. We fully understand the rationale for that. The importance to prevent players from monopolizing infrastructure and reducing competition. But I think there are some really important nuances that need to be understood around how LNG works, which is very different from a pipeline gas infrastructure. And I think the first point to potentially raise is that if you look at liquefied natural gas import infrastructure, it's being financed by and being built by parties that are really utility type investors. They tend to be quite risk averse, and they tend to look to either big gas customers or big gas suppliers to reserve capacity up front to allow for them to finance and bank those facilities. And so what you're asking suppliers and buyers to do is effectively take risk, long-term risk, by reserving capacity over a 10, 15, 20-year period, which then allows the investor and the developer of the infrastructure to just get the financing to build that infrastructure. And some of these provisions, unless they're more carefully constructed, could actually provide risk to some of these parties that are effectively financing and taking the risk to ensure these facilities get developed. And the concern is that they may find themselves booking capacity and then having that capacity removed from them, and having to onsell that to other parties. And then I think the key issue that needs to be understood is how differently LNG import facilities operate versus a pipeline. And so you cannot use the same rules for uncommitted capacity for a pipeline with LNG infrastructure. And that's really illustrated in the next slide, where we've just show how, typically a LNG tank and LNG storage infrastructure, the amount of capacity within that infrastructure varies over time based on delivery schedules and the requirements of the downstream offtake. And these aspects really need to be carefully considered as the provisions of the Act get taken forward. So finally, honourable members, I think what we just want to highlight is that there is, as has previously been stated, a number of aspects of this bill that are really important and we would commend, particularly the areas where the minister has been given powers to drive, greater coordination and through and development of play a stronger role to ensure the development of critical gas infrastructure, particularly as that can provide some degree of greater certainty for private sector capital to be mobilized and for greater cooperation between public and private sectors. But what we do really want to urge is that in these areas of the bill where provisions have come in which potentially create a degree of uncertainty, as well as trying to fit aspects of regulation and legislation that might have suited a pipeline gas market onto an LNG market, that these be considered and potentially improved upon. We believe if these areas are considered, then this bill would in fact be an important step forward in the development of South Africa's gas industry. And with those few comments, I'd like to thank the members for your time and for the opportunity to present, and I'll stay on for questions should there be any at the end. Thank you. I'll stop sharing now, and thank you, Chair.
Thank you very much for that presentation, Africa International Advisor. We now move on to NERSA.
NERSA, I've given Theodora Koza the co-hosting rights.
Good afternoon, Honorable Chairperson, and to the members of the committee. My name is Nomfundo Maseti. I am the full-time regulator member responsible for the regulation of gas at NERSA. And I just want to thank the committee for giving us the opportunity to present today. I believe that it will also greatly assist the committee as we worked in this industry, at least from my side. I worked in this industry for a period of 13 years at the level of the full-time regulator member. And I have 27 years in the space of regulation from the competition authorities and also from the telecommunication, and now again on the sector regulation for economic regulation, just to give the context of my involvement on these matters. And also, if I may indicate that, Chairperson, the team from NERSA worked very closely with the department in this bill, and we appreciate that opportunity because we'll remain as a resource to the department insofar as the department needs to understand what are the challenges in the implementation of the legislation, how the department can also facilitate the strengthening of NERSA's functions and effectiveness in the regulation of the gas industry. And that opportunity assisted a great deal because it will also give the members of Parliament as well as the department a better sense of why there should be changes, so that changes in policy and legislation are not based on assumptions and what one may want to see, but the changes are well informed by the practical challenges that the regulator is facing in trying to achieve the policy imperative in the law that we are administering. We believe that I will be able to do some justice in giving that feedback to the members of the committee with this presentation. May I request that it be, I'm unable to see properly here. If it can be expanded, Theodora, I can't see at all. If you can please just assist with expansion of the presentation. I'm unable to see, but I would like to just start off with the context, as I'm unable to see the context of the outline of the presentation. In terms of the outline of the presentation, I will touch just on the introduction, the key policy imperatives and objectives, as well as the amendments that are proposed herein, which we support at NERSA, because we believe that they will strengthen the regulatory mandate and be able to enable the regulator to make the changes and transformation that we want to see in the gas market. I would like to then start off with the introduction without wasting any time or time for the committee. NERSA is empowered to regulate 3 industries. One is the gas, second one is electricity, as well as petroleum pipelines. So petroleum is only the infrastructure currently that is being regulated by NERSA. So in terms of our responsibilities at NERSA, just to give the background, is that NERSA is responsible for the implementation of this law, the bill, but at the moment it is the Gas Act as well as the rules and regulations that form part of this regulatory framework. And just one of the key functions of NERSA is to promote competitive gas markets, as well as to facilitate investment and ensure the orderly development of the gas infrastructure in the industry. There are other socio-economic objectives that are in the Act, and also in the regulations, so that when we take decisions, we are able to take decisions that will ensure that, for instance, the HDSAs are promoted and they're also inclusive, as well as the small companies, they have the opportunity to participate meaningfully in the gas market. And this is quite important because the gas market is faced with structural challenges for participation and fairness in the participation. And that is very important in terms of making sure that as we implement for a purpose, and that there's going to be a change in the market. Now, in terms of the second slide, it just deals with the key implementation objectives, which I've already stated earlier on, the one that deals with just strengthening our power so that we can be decisive in dealing with the conduct that is not proper in the market. And that conduct is the conduct that deals also with the prices, with the tariffs, with the access to third parties, as we know that some infrastructure is a natural monopoly, so it cannot be easily duplicated. And we will also show practical outcomes that show that NERSA, through its interventions, has enabled entrance of small companies to participate in the trading of gas. And when we did so, because we're also given powers, even though the powers were weak, but we managed to ensure that those companies, when they enter the market, some of which are Black-owned companies, they will be in a position to stay in the market and participate. So this slide is meant to put an emphasis on those strategic objectives. I would like to go straight now to the key amendments that are meant to strengthen the regulatory powers. I want to spend just 2 or so minutes in terms of the clauses that are in the bill. The one clause that is giving NERSA the powers now of not just approving, but to set prices. And this is a critical a mandate that is being proposed here, because when you are facing a market that is characterized by structural challenges to start off with, and certain constraints even for participation, number one. Number two, where there is no competition, it means that some will be exposed to exploitative pricing and excessive pricing, something that by the existence of the regulator, if you're in economic regulation, you should be in a position to curtail that market power, which manifests itself in terms of high prices. And that's exactly what Section 21(1)(p) seeks to do, because the market is characterized by a monopoly or a dominant structure. You cannot leave others to be exposed to whatever price that is being charged. And this is quite critical, because at the time when I actually led the transition from the regulatory agreement, the prices at the time, and which this is actually what caused some of the weaknesses in the Gas Act when even these agreements were negotiated, and what outcomes did we see now from the regulator? Now that we've got the pieces of legal documents, one, the Gas Act, secondly, the regulatory agreement for the Mozambican gas. We realized that prices were so high, and to an extent, to give you a flavor of this, the unit price will sit at about 300 rands per gigajoule. Now, if you compare with where the maximum prices are sitting, today they're sitting at 87 rands per gigajoule. And that is because through the years, since 2005 to date, NERSA had to step in through its methodologies to make sure that we regulate prices because competition is not there. So that period is a period where you can clearly see the exercise of market power through the market value pricing, which was followed thereafter by comparison with other prices such as LPG prices that are not regulated by NERSA. And so other parties, it was very difficult for them to, especially small companies or customers, they were experiencing very high prices. And yes, also the discrimination was very pervasive at the time. But we managed to come in and reduce that. But what we have noticed as well is that the fact that competition is not there, the light-handed regulation of saying approve instead of setting, it has presented practical situations where sometimes parties deliberately, where we could have set the price, say at 70 rands, it might actually get to 72 rands because there's a slight difference there. And it is because that price is a price where a dominant player has applied to NERSA. So we do need the powers where we are not dictated and try to align ourselves with what is calculated. I spent a bit of time just on that so that I can clarify that issue. The second issue is the tariffs. The tariffs there on distribution, I think this is one that has been mentioned. Again, a practical example of a monopoly exploiting. Now, on transmission, we regulate, and the price is sitting, or the tariff is sitting at 7 rands per gigajoule, which is a big infrastructure compared to distribution. Now, distribution, the price, the tariff is sitting at around, I think it's around 20 rands or 21 rands. And that's where there's also an exploitation on the monopoly because it's not regulated. And that is actually one of the gaps that we noticed at the time that legislation was passed through Parliament and during that regulatory agreement. So what we are requesting is that we are given the powers even on the huge infrastructure, regasification, LNG, as some of the stakeholders have touched on that, and the bill is doing that, and we support that. But on distribution, again, there are problems. Not everyone is going to build distribution pipelines. So what is important is that there's a need for a third-party access on distribution. On transmission, that third-party access is there, as well as on storage. It is not there on distribution. So that's also the part that we just wanted to make sure that the members of the committee they do empower the regulator to be able to deal with these things and the outcomes that we are seeing, which are very exploitative tariffs that we can't do anything about. So I have also just provided, I would like to move on to the next slide. I've already given the examples of those prices that are sitting there for distribution as well as the transmission. Now, with the third-party access, I have also put the economic rationale there. One, the rationale that these assets are huge and they require intensive capital, and they are natural monopolies. You don't want to duplicate them. Even the big infrastructure, the LNGs and regasification, fixed terminals. So it's very important if we want to transform the industry, if we want to make sure that at least you enable the regulator to regulate for inclusivity, that no one is going to be left outside of participating in these markets. Yes, they will pay the fee, but if they get an opportunity or access to gas from any source, then they should be able to utilize those the big infrastructure so that we can see that meaningful participation that will ensure that these industries are transformed, but not only to transform, but to ensure inclusivity as we regulate. So that is the essence of what we are putting under the mandatory third-party access, and which we want to see not only in distribution pipelines, but also in regasification facilities that are being considered in the country. And we believe that that would assist a great deal. And then the other powers that we want to just specify is that market evolves. The regulator should be technology neutral. We would not want the gaps where there are other parts of sort of monopoly markets that we are not able to regulate, because the definition of of gas is limiting and the market keeps on changing rapidly. So and this actually we have seen it because NERSA's mandate was now determined by the courts, and they were blaming what is in our own act. Whilst the act is mentioning LNG, that NERSA, you can do this, it was not tight enough. It said piped gas, and therefore we were taken to court, and there are people that are operating the very facilities that the act say we must have a say. So that say, the courts have turned it around, and they mentioned in the courts that now the bill is there, so you will have the opportunity, NERSA, only if the bill enables you to regulate those other markets. So that is the point we're emphasizing on Roman numeral 4. And Roman numeral 5 also, as other stakeholders have indicated, that even in low carbon and renewable gases, whether it's blue or and the green hydrogen and so forth, as market is evolving, we are supporting what the bill is proposing in terms of regulating
Chair, the
this.
slides are not moving, eh?
I don't know
The
what's
slides
going
are
on.
not moving.
Theo, can you please move the slides I was directing here? Is slide 9 of 16 now? Slide 9 of 16.
It's fine, Mema Sete. Let me project.
Okay. All right. Thank you very much. I've dealt with all of the other slides and summarized them as we showed. Now, members, I would like to deal with the issue of exclusivity. That issue of exclusivity, I think in the current Gas Act is in 3 sections of the Act. Section 21, 1, I think it's M, N, and K. Those sections are quite problematic, and we have seen them because you may find a situation where a small company that wants to enter the market and it has secured gas, maybe with whatever volumes, say from Mozambique, is unable to what you call to trade in areas where there is a distributor that is given exclusivity. That is problematic because it will mean that we need to check whether prices are competitive in those markets, and it will keep others outside of the market. So that issue needs also to be dealt with. Hence, we are proposing that in both regasification, nobody is going to duplicate that infrastructure for regasification, for instance, in the fixed terminals. So we need to have third-party access there. If there's going to be, for instance, the Zululand LNG regasification terminal, there should be third-party access for participation there, so that there is no exclusivity. And the other thing that this, we believe that it will erase issues of uncertainty, but at the same time, it will introduce competition. It will also give other parties, whether small parties, an opportunity to participate in the market. And those are the critical policy rationale that we believe that the department and the committee is on the right track to look into carefully, because we regulate so that we can see the market conditions, the changes, and whether the ordinary people and other people structurally will have fair opportunities in the changes that are taking place in this country. In terms of the registration conditions, terms, and non-transferability of the license, we appreciate the fact that NERSA is given the opportunity to now have powers to transfer the license, and these powers must be expressed, and also that on that concern as well, because there are other stakeholders when we're coming up with these proposals that we're quite concerned about transferability of license. Transferability of license, it would not be the first time that we look at it at NERSA. We are doing it in electricity. We decide on these matters, and it's quite a good thing because you find that the lenders that were there at the beginning, sometimes they change. There's a change in control of that company because sometimes they just want to get out of that project, and others can come in. That provides investor confidence, and we believe that it is a proper thing to do. So by giving NERSA the powers,
As we move towards conclusion, because time is up.
Okay. All right. Thanks, Chair. If we then look into that, Chair, I'm not going to deal with the others. I will just indicate that the transferability is something that is done around the world, and it would not threaten the investors. It will in fact provide regulatory certainty, and if NERSA is allowed to do so. And then coming to the additional amendments, Chair, have to do with the enable NERSA to impose license application. This is not the levy, but when big applicants or companies come to NERSA and they're applying for a license. So NERSA utilizes its resources to do so. And also, we make sure that not only one company that pays the levies and the others, all of the big companies that come in, they are not going to contribute to the resources that are utilized by NERSA. And also it will make sure that there are efficiencies, because sometimes others will bring applications that are incomplete, take too long, and yet NERSA is utilizing its resources. We believe that this will go a long way to assist the regulator. The other minor ones, Chairperson, are just alignments that are quite important. The last point, Chairperson, of the committee is if this can move on the slides. The other issue is on the issue of the excessive pricing, that the regulator is given powers on the excessive pricing. Those pricing are the excessive pricing authority or powers, they have been there, and it's quite an important clarity that is needed. There is no doubt in South Africa we already have concurrent jurisdiction. It is not something that we can do only in this legislation. It is in there's a governing statement on concurrent jurisdiction in terms of Section 3 of the Competition Act. I practiced in that act for a number of years. And I also dealt with the concurrent jurisdiction in Parliament, taking a bill on telecommunication and the Competition Act. So the government of this country has already adopted the principle of concurrent jurisdiction. And in addition to that, the government did not leave it hanging. It has the mechanism of how you manage it. It states clearly in Section 21K of the Competition Act and Section 80 that the regulatory bodies must manage this in a harmonized manner by entering into the memorandum of agreements. And we do have a memorandum of agreement from our side with the Competition Commission. So I would like to end it here, Chairperson, and then I will take questions later on just to provide a clarity. I thank you very much, Honorable Chair, for the opportunity. Thank you.
Thank you, NAPSA. We will now take the final presentation for today from groundwork and then move on to clarity seeking questions.
Thank you. Thank you so much, Chair. I'll share my screen shortly. Hoping that you're able to see my presentation.
Yes.
Cool. Yeah, Chairperson, honorable members of the committee, good afternoon. Thank you so much for the opportunity to make this presentation on Groundwork's behalf. We support the need for an effective and modern regulatory framework for the downstream gas sector. The transmission, storage, liquefaction, regasification, and distribution of gas requires clear regulatory responsibilities, effective oversight, and appropriate safety standards. And our submission is, however, concerned with the strategic direction of the regulatory framework. The Gas Act of 2001 was developed under substantially different economic, technological, and policy conditions. So since then, South Africa has adopted, comprehensive climate legislation, renewable energy and storage technologies have developed quite considerably, and international markets are placing increasing emphasis on the decarbonization of industrial production. So the bill will also operate in a context of considerable uncertainty regarding future gas demand, domestic supply, and the economics of new gas infrastructure. So this matters because downstream infrastructure is long-lived. decisions taken through the regulatory framework established by this particular bill influence investment and energy system choices for several decades. So we therefore consider that the bill should do more than provide the regulatory certainty for the gas sector or the gas industry. It should establish a framework capable of managing the sector through the energy transition, including the eventual decline of fossil gas demand. So this is consistent with the central concern in our written submission, that regulation should remain aligned with South Africa's long-term economic interests, constitutional obligations, as well as climate commitments, as well as the just transition objectives. So, sorry, I'm here now. So our first substantive concern relates to the economic implications of downstream gas infrastructure. The development of gas infrastructure requires confidence in both future supply and sustained demand. South Africa's experience over the past decade suggests that these assumptions require considerably more scrutiny than they've sometimes received. Proposed developments in the Free State, in KwaZulu-Natal, in Mpumalanga have experienced prolonged uncertainty, while imported LNG remains exposed to international price volatility and geopolitical conditions. These developments are relevant to the bill, even where they fall outside its direct upstream regulatory scope, because supply and demand conditions ultimately affect the viability of downstream infrastructure. There's also a particular affordability concern where gas to power is used as an anchor for investment in gas infrastructure. So where infrastructure is developed on the basis of electricity demand, there needs to be transparency about the allocation of costs between electricity consumers and other users on the gas network. So the bill should therefore provide for a proper assessment of, one, the projected demand, the infrastructure utilization, affordability, alternative technologies, long-term supply conditions, as well as the stranded asset risks. This is particularly important where infrastructure has a lifespan well beyond the period in which the assumptions underpinning the investment may remain valid. The objective should be to ensure that the regulatory certainty does not become a mechanism for transferring poorly understood long-term risks to consumers or the public sector. So on matters relating to the industrial demand and the bill's implications extends beyond electricity generation. Gas is used across industrial sectors, including manufacturing, petrochemical sector, glass and ceramics. So we recognize that the technological requirements of these industries differ, and that the transition away from fossil fuels will not occur uniformly. There should be a distinction between the legitimate transitional requirements and the assumptions of permanent gas demand. So alternative technologies are also developing across a number of industrial applications, while international trade is increasingly influenced by carbon-related requirements. Industrial competitiveness will consequently depend not only on access to energy, but increasingly on access to energy that is compatible with a lower carbon economy. So the regulatory framework should respond to these developments rather than just assume that existing patterns of fossil gas consumption will continue unchanged. We therefore recommend that the bill provide for periodic assessments of gas demand and market conditions, taking into consideration technological developments, industrial decarbonization, affordability, and South Africa's climate commitments. So this would allow the regulatory framework to remain responsive as the energy sector changes. On methane and life cycle emissions, a further area that requires strengthening, in our opinion, is the treatment of methane emissions. The climate implications of gas cannot be assessed solely at the point of combustion. Methane emissions occur throughout the downstream value chain, including liquefaction, storage, shipping, regasification, transmission, and distribution. So this is particularly significant for LNG, where the additional stages of supply chain introduce further opportunities for methane loss. So the shorter atmospheric timescale of methane is also important. Given the urgency of limiting near-term warming, the 20-year global warming potential provides a particularly relevant basis for understanding its climate significance. So in our written submissions, you will note that we draw your attention on relevant literature that make this point. So the bill therefore should provide for more explicit methane governance. At minimum, this should include measurements and the monitoring of methane emissions, leak detection and repair, the independent verification of emissions data, as well as routine public reporting. So NESA's regulatory function should also take account of life cycle greenhouse gas emissions while considering the major downstream infrastructure. This would bring the regulatory framework more closely into line with South Africa's broader climate governance obligations. On transparency, information, and public accountability. So that's the fifth. The fifth issue relates to transparency and access to information. We recognize the legitimate need to protect commercially sensitive and proprietary information. However, the bill's current provisions create a distinction between information that cannot be disclosed because it's confidential or commercially sensitive, and information whose disclosure is left to the discretion of the regulator. We consider that this requires greater protection in the public interest. The operation of gas infrastructure has implications for consumers, for communities, for environmental quality, for public safety, and potentially public expenditure. So meaningful oversight, therefore, depends on access to appropriate information, in particular, information concerning methane emissions, environmental monitoring, licensing conditions, compliance, enforcement action, safety performance, as well as material public costs. So should generally be, these should generally be available for public scrutiny, subject to narrowly defined and legitimate confidentiality requirements. The objective is not unrestricted disclosure of commercially sensitive information. It is to ensure that the commercial confidentiality does not unnecessarily limit regulatory accountability and meaningful public participation. On safety and the management of the sector's decline, we also recommend strengthening the bill's approach to safety and the full life cycle of gas infrastructure. Now, modern regulation should provide clear requirements for the safe design, construction, operation, maintenance, and monitoring of gas infrastructure. It should also provide clarity regarding emergency preparedness, operator responsibilities, and enforcement. So given the long-term lived nature of gas infrastructure, the regulatory framework should additionally anticipate closure and decommissioning. So this is particularly important in the context of an energy transition. So infrastructure developed today may remain operational into a period in which gas demand has materially declined. So the costs and responsibilities associated with closure should therefore not be left as an unresolved future liability. So a comprehensive regulatory framework should establish clear accountability for the full life cycle of infrastructure, including its eventual retirement. So more broadly, we suggest that the bill should also support an orderly decline of fossil gas dependence rather than creating regulatory incentives for infrastructure expansion that may become inconsistent with South Africa's future energy and climate objectives. So, Chairperson and members of this committee, our principal recommendations are therefore the following. First, the bill should explicitly require that downstream gas regulation should be consistent with the Climate Change Act, with NEMA, with Section 24 of the Constitution, and South Africa's emission reduction commitments. Secondly, major gas infrastructure should be subject to proper assessment of demand, affordability, alternative technologies, and stranded asset risk, particularly where gas to power creates the anchor demand. Third, the bill should establish stronger requirements for methane monitoring, leak detection and repair, independent verification and public monitoring. Fourthly, the information provisions should establish a much stronger presumption in favor of disclosure of information relevant to environmental performance, emissions, safety and compliance, and public costs. Fifth, the regulatory framework should require periodic review of gas infrastructure and market conditions, taking into account technological change, industrial decarbonization, gas demand, and climate obligations. So these recommendations are already reflected in the written submission. And sixth, the bill should strengthen provisions relating to safety, to closure, to decommissioning, ensuring that responsibilities and costs are clearly allocated across the infrastructure lifecycle. Finally, we recommend that Parliament consider that the bill within the broader trajectory of South Africa's energy transition. So we do not consider modernization of the regulatory framework and an eventual decline in fossil gas dependence to be contradictory objectives. On the contrary, a modern framework should be capable of regulating the sector effectively while also participating in or while anticipating changes in technology, changes in markets, as well as changes in climate policy. And in closure, South Africa's gas sector requires effective regulation. So the issue before Parliament is the design of that regulation and the assumptions that underpin it. So the gas bill, this particular gas bill, provides an opportunity to establish a framework that is economically prudent, environmentally responsible, transparent, and capable of responding to a changing energy system. So in our view, this means moving beyond a regulatory approach or framework centered primarily on facilitating investment and towards one that addresses affordability, that addresses climate risk, that addresses methane emissions, safety, public accountability, and the long-term viability of infrastructure. So the objective should be a gas sector that is appropriately regulated during the transition, while also avoiding unnecessary investment in South Africa, or in infrastructure rather, that could lock South Africa into long-term fossil gas dependence. So that is the basis of groundwork submission. Thank you so much, Chairperson. Thanks.
Thank you very much for that presentation. I will now take hands regarding seeking questions from honorable members. With lack of hands, regarding seeking, it means the presentation is quite clear. But I also do just want to reiterate that we are going to be engaging on all the presentations, the ones we've received today and the ones we are still to receive tomorrow on the 18th. That is a day set for action deliberation. Today we would be asking questions where there are certain parts of the presentations that we just need clarity on, so that when we do deliberate, we are quite clear as to what each stakeholder intended to say in their presentation. We do want to appreciate all the presentations that were thorough and that do demonstrate quite an effort put in preparing. And it really does assist us, because as we engage in lawmaking, we want to make sure that we have involved the public in the discussion, and all the stakeholders and entities that have an interest on the bill at hand. And I do want to say that it was quite presentations of quality, and we look forward to more of this tomorrow. With those words, we thank everyone who participated, and we thank our support staff that have been assisting us from the time of advertising, calling for the comments, and also the department for availing itself where it needs to, so that we have a good packaging of this particular process. So with those words, I do wish you everyone a great day further. Let's meet tomorrow when we conclude on this public hearing. Thank you very much.
Thank you, Chair.
Thank you, Honorable Chair, everybody.
Recording stopped.